Good morning, we're on the record. Good morning, everyone. As chairperson of the Alcoholic Beverage Control Board for the District of Columbia, and in accordance with DC Code Section 2571 of the Open Meetings Act, OMA, I am welcoming you to the regular scheduled meeting of the Alcoholic Beverage Control Board. This meeting is being conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABRA's website and on the District Central meeting calendar. The notice included the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairman of the board. I would like to introduce the other ABC board members who are also participating electronically. Please respond when I announce your name. Mr. James Short.
Mr. James Short, present.
Ms. Rafi Crockett.
Rafi Crockett, present.
Ms. Jenny Henson.
Jenny Henson, present.
Mr. Edward Grandis.
Grandis, present.
The board has 5 members in attendance today for the conduct of business, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 6 cases scheduled on this morning's calendar. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and equipment, camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first case today is a protest hearing status, which is case number 22 PRO 00068, Lidell, license number 119890. Mr. Oriana, can you please elevate the rights of the parties in this case, please?
Commissioner T. Brown, your access has been elevated. O'Brien, your access has been elevated. That is all, Chairman.
Thank you.
Good morning, Mr. Chair. Stephen O'Brien for the legal.
Please spell your name for the record, please, Mr. O'Brien.
Yes, it's STEPHEN. Last name O''BRIEN.
Good morning. Commissioner Brown, can you please identify yourself for the record, please?
Sure. Tiffany Brown, ANC Commissioner for 7B02, also Chair of ANC 7B.
Good morning. All right. Good morning, everyone. This is a protest hearing status on Lidell. And it is my understanding that the applicant had signed a motion to dismiss, and also that the protester had responded. And just for the record, it's those cases are on our legal agenda for us to review and make a decision today. And so, Mr. O'Brien, can you just briefly share the reason for your motion to dismiss?
Surely. The facts as they have developed are not in dispute here. At some point prior to the June 16 ANC meeting, a decision was made on behalf of the ANC to protest this change of hours application. Now, how do we know that? We know that because on the June 16 ANC agenda, this is on a consent calendar. Consent, of course, means agreement. Sometime prior to the meeting, the decision was made to protest it. Now, the purpose of a consent calendar is to avoid and preclude discussion at the meeting. Now, we know that at the meeting, there was absolutely no discussion of peace, order, and quiet. We know that from listening to the tape of the meeting. Yet somehow, a June 16 letter is filed with the board saying that on that date, the ANC protested on the grounds of peace, order, and quiet. It simply didn't happen, as represented in that letter. And we know that now. The ANC is subject to the Open Meetings Act, as is the board. Okay? And no action is to be taken unless it's at a public meeting. But here, the decision was made in advance and rubber stamped at the meeting. The June 16th letter to the board is a falsity. What it says happened never happened. And the ANC is required to play by the rules. It did not in this case. The protest was not adopted in accordance with required procedures. And that, for that reason, it has to be dismissed.
Ms. Brown, I know that you had, it's my understanding that the response that was provided, you first provided the agency with a consent calendar. I think that a consent agenda, that I think that's what you provided to the agency. And then I think it's my understanding that yesterday you provided some additional information. So can you please just briefly respond to the motion, please?
Sure. So what we provided to the agency initially was an audio recording of the meeting. And then we came back and provided a meeting notice along with the agenda to the agency. And I believe that was on Monday. That meeting absolutely happened. We absolutely voted on it. Our agenda is set in such a way that there are items in there that we don't have to necessarily vote on each one. The commissioners had a draft copy of the letter and the other things in the consent agenda. That did not mean that we agreed on it before. What we had agreed on were these were the things that were going to be in the consent agenda. If commissioners did not want it, the things in there, commissioners could have pulled things out. We all agreed to the things that were in the consent agenda, and we agreed at that time. And that's why the letter was such. Our meetings are open, and people are more than welcome to come. Mr. O'Brien has never attended one of our meetings, so I'm not sure why he said that it did not happen. We voted on that protest letter at the June 16th meeting.
Any questions? Any questions by any board members? Any comments, because the board needs to vote on whether or not to grant the motion or deny the motion. Any comments? Any final comments you want to make, Commissioner Brown? And then I'm going to give you an opportunity to Mr. O'Brien prior to the board voting whether or not we will grant or deny the motion.
So I would just like to say that from the whole applicant's, from the start of the applicant, we had tried to engage in a settlement agreement, a good neighbor agreement with Lytle, and that never happened. We have been through this several times with the applicant, and they just won't agree to a settlement agreement. We are so happy Lytle is there. They opened up officially this morning. We just want them to be a nice neighbor in our community. And that's just it. The board has already granted them a liquor license. And so I really don't see the need why they need to extend their hours. It should have been on the initial application, and I had stated that when we had gone through mediation before. So it's a matter of changing the hours. we don't necessarily, the commission does not necessarily have an issue with them extending the hours. The issue is that we would like for them to enter into a good neighbor agreement so that we all can be held accountable.
Mr. O'Brien?
That's really the crux of this appeal. I'm sorry, of this protest. It's failure to knuckle under and agree to a settlement agreement. Failure or refusal to agree to a settlement agreement is not a valid grounds for protest. And in her argument, the commissioner has again confirmed the facts here. A decision was made in advance to protest, in advance of the meeting. That's why it was on the consent calendar. It was a railroad job.
No.
Done deal by the time the meeting was called to order. Thank you.
I just want to ask you a quick question, Commissioner Brown.
Sure.
Can you confirm that the ANC letter that was on file with the board, that it was available to ANC members at the vote?
Yes.
Yeah. All right.
Mr. Chair, may I note that the transcript, the tape does not confirm that.
Any other questions? Any questions by the board members before we vote? I'm gonna make a motion to the board that the motion filed by the applicant be granted, and on the reasons why I'll be making that motion to the board that the motion be granted is that in this case the document provided by the ANC showed that the matter was publicly noticed. But however, there is no evidence that any appropriateness issues were discussed or otherwise under consideration. In particular, there is no evidence that any draft proposed letters containing the grounds raised by the ANC and its proposal that was provided. Well, no. Hold on. I'm gonna withdraw my motion. We're gonna take this under advisement. Okay, so we're gonna we will take the motion under advisement and make a decision whether or not we will grant or deny the motion. So I am withdrawing the motion that was made. So basically where we are right now, this matter, I know that the preliminary issue that was filed by you, Mr. O'Brien, and I know the ANC had responded. And so where we are, this matter is then currently scheduled for a protest hearing on October 5th, 2022 at 1:30 p.m. I know this is somewhat convoluted. One of the question that was asked, the last question that I'd asked about whether or not the letter was shared previously with the ANC. That's an issue that the board has to reconsider whether or not the matter, whether or not it's clear that this was discussed at the protest hearing. So the board will take this matter under consideration and decide whether or not we're going to grant or deny the motion.
Mr. Chairman?
Yes, Mr. Grandis.
Just so I have clarity, it's my understanding from what I could see in our record that the ANC filed a protest on this substantial change, and that their letter noted the date of their meeting and what the vote was. And this matter has been, or this request for a protest has actually gone to a roll call. And at roll call, they were found that they had standing. I'm just making sure I understand where we are with this.
Yes. However, but what the argument that's been made by the applicant is that if a matter is protested, it has to be noticed. It has to be noticed to the public. It has to be noticed to the other ANC members, and also at the protest hearing, at the ANC public meeting, that the public has to vote under peace, vote to protest this matter under peace, order, and quiet, because that's the standard appropriateness, peace, order, and quiet. So that's the standard that has to be discussed, and the public has to that has to be addressed at a public meeting
by the ANC.
By the ANC, right?
Yeah. So once again, my question is there a concern that we have discussed that the letter is deficient and doesn't meet those standards, or at roll call, was it deemed that the elements that allowed the ANC to request to be a protestant were met? Because I'm confused a bit about what exactly what we could discuss, because we weren't at that meeting, so I'm trying to figure out what is there for us to discuss.
Or as you're aware, Mr. Grandis, a party can make a jurisdictional issue, raise a jurisdictional issue.
Okay, so that's what you're okay.
So this is where we are. So
okay,
standing was granted to the ANC at roll call. However, subsequent to roll call, the applicant has raised a substantive issue, saying that certain procedures were not raised at the ANC meeting, so therefore we should not grant stand-in to the ANC to move forward. And that was what was raised in Mr. O'Brien's motion, and the motion was raised after stand-in was granted to the ANC. There are certain documents that were provided when council filed its motion, and I also signed off on a subpoena because council had requested a copy, a recording of the ANC meeting, and I signed off on the subpoena. Council received the recording of the ANC meeting, and so pursuant to receiving the documents, that is the argument. That's why the motion was raised, and the ANC responded. There are some legal issues that need to be further investigated. I think the seminal issue that we had, which we weren't aware of this morning, is whether or not the document was whether so where the board is right now is whether or not, or from a legal perspective, for us to make this decision on our legal agenda this morning, is whether or not the letter that was whether or not the letter was shared with the ANC, with the other commissioners that was provided to us. And Commissioner Brown has confirmed that this information was available to all the other commissioners. And so therefore the board needs to make a legal determination whether or not this is appropriate. And so that's one of the reasons why, although I was not aware that prior to the response from Commissioner Brown, and so therefore I need the assistance of our legal office to further make a determination whether or not we should grant this motion or deny the motion. And so that's basically where we are today. So that's why I withdraw my motion to grant. That's why I withdraw the motion that I was going to make to grant the motion to dismiss. So we'll take this under consideration. That doesn't mean that we're not going to grant it. I don't know. We just need to, from a legal perspective, have some more legal analysis to see whether or not the standards have been met for this matter to move forward. Okay. All right. Any other questions by any board members? And as I stated, this matter is scheduled for a protest hearing on October 25th, 2022. And the board will, we have our legal agenda, and so we'll further discuss this matter on our legal agenda that we will issue later on this morning. And on our legal agenda, we'll either grant the motion or deny the motion. Okay. All right. Any other questions by the parties?
No, sir.
So I just wanted to make a statement. I was not asked to provide proof that the letter went to the commissioners beforehand. I can go into my outbox and provide that also, because it was indeed provided to the commissioners beforehand. It wasn't just on the consent agenda.
As I asked you the question, I asked you the question. That was a legal. Okay. That was a legal question that I'd asked you this morning, Commissioner Brown. Okay. And you have answered affirmatively that this was shared. And so this is something that's important from a legal decision for us to make that. And so therefore the board will take your response in consideration to make a determination whether or not we're going to grant or deny your motion. And so we will announce later on this morning what our decision is on the motion. Yes, Mr. Brown.
Mr. Chair, in response to what Commissioner Brown just said, if one listens to the tape of the meeting, there is no discussion about a letter that you already have seen, a draft letter you've already seen. There's no discussion of that. And most importantly, and I say a determinative, is there is no discussion at that meeting of peace, order, and quiet. And the letter that says that it was adopted on peace, order, and quiet at that meeting is just plain factually inaccurate.
Not true.
And in response to what Mr. Grandis, the questions Mr. Grandis asked, is at roll call, the letter facially was sufficient to confirm standing, but investigation after roll call has led to this motion to dismiss.
As I stated, Mr. O'Brien, we will again review your motion and the response, and with the assistance of our legal staff, we will make a decision this morning on our legal. As you know, we have our legal agenda. Our legal agenda, that your motion is on our legal agenda, and the response by the ANC, the two responses by the ANC, it's on our legal agenda, and so we will make a decision based on the documents that are provided to us. Okay.
Thank you, Mr. Chair.
All right, thank you. But I said before, if this matter is not dismissed, then the protest hearing is scheduled for October 5th at 1:30 p.m. All right, thank you very much.
Thank you.
Thank you.
Bye-bye. All right, we now move to our show cause hearing status calendar. The first case in our show cause hearing status calendar is case number 22-251-00018, Moi Moi Restaurant, license number 120466. Mr. Oriana, can you please elevate the rights of the licensee and the government in this case, please?
Alan Chenchi, your access has been elevated. I do not see the licensee's counsel present. That is all, Chairman.
The licensee is not represented by counsel, so I would ask whether or not the licensee itself is there. And let me see the name. The licensee is not represented by counsel. I do not have the name of the licensee in front of me. But is there anyone? Is there anyone from Moi Moi Restaurant? Can you please identify yourself on the chat, please? Can you please identify yourself for the chat if you're here for Moi Moi Restaurant, Moi Moi. All right, there's what's your name? The person who says I'm here from Moi Moi. What is your name, please? So we'll elevate your rights. Oh, I'm sorry. I was just reading. All right, I apologize. the comments I was reading in the chat was that if you're here, please advise. All right. This matter was scheduled for a show cause hearing at status at 10:30. It's now 11:04. So, Mr. Chenchi, can you please spell and state your name for the record, please?
Morning, Mr. Chair. Colin Chenci, COLLINCENCI, representing the district today.
Good morning, sir. I see that the licensee is not here. Then this matter is scheduled for a show cause hearing on October 19th, 2022 at 10:30 a.m. Okay, thank you, sir. The next case in our calendar is case number 21 CIT 00704, Service Bar, license number 103008. This case, we've had some service of process issues, so this case has been continued to a date to be determined. The next case in our calendar is case number 22 CMP 00037. Nerozeno, license number 110949. Mr. Oriana, can you please elevate the rights of the licensee in this case, please?
Sidon Johannes, your access has been elevated. That is all, Chairman.
Thank you. Mr. Chenchi, good morning again. Can you please state your name for the record, please?
Colin Chenchi, representing the district today.
Good morning. Ms. Johannes, can you please spell and state your name for the record, please?
Sidon Johannes, here on behalf of the licensee, and that is SIDONYOHANNES.
Thank you. Good morning. Mr. Chenchi, are there any preliminary matters in this case?
None from the district, Your Honor, Mr. Chair.
All right, thank you. All right, then this matter is scheduled for a show cause hearing on October 19th, 2022 at 1:30 p.m. Thank you very much. Just want to remind the parties that if this matter goes to a show cause hearing, then 7 days prior to the hearing, each side is required to file documents and witnesses that will be relied upon at the hearing. If the parties fail to provide us 7 days prior to the hearing with documents and witnesses that will be relied, unless good cause is shown, the board will vote to prevent that person from introducing those documents or records that have witnesses that have not been disclosed 7 days prior to the hearing. Is that clear with everyone?
Yes, thank you.
All right, thank you.
Mr. Chair.
All right, have a great day then. The next case in our calendar, the case number 22 CMP 00014, Empire Lounge, license number 110704. This case has been continued to October 26, 2022 at 1:30 p.m. at the request of the respondent with the consent of the government. And our last case for the morning is a fact-finding hearing, case number 22-251-00022, Tora, license number 91165. Mr. Oriana, can you please elevate the rights of the licensee, the boards and the licensee in this case, and the board's witness, please?
Igor Radakovic, your access has been elevated. Andrew Klein, your access has been elevated. Christopher Condon, your access has been elevated. That is all, Chairman.
Thank you very much. Mr. Condon, I do not see you. Thank you. Mr. Radakovic, do you have a camera you can turn on, sir?
Yes. Here you go.
I still don't see you, but all right, that's fine.
Should be on.
Okay, fine. Good morning. Yes, I can see you now.
Good morning.
Good morning. All right. I would like the parties to identify themselves for the record. So let me start with our investigator. Can you please spell and state your name for the record, please?
Sure, it's Christopher Condon, Christopher. Last name's Condon, Condon.
Thank you, Mr. Klein. Can you please spell and state your name for the record, please?
Good morning, Mr. Chairman, members of the board. Andrew Klein, Andrew Klein, Kline, counsel for the licensee.
Mr. Radakovic, can you please spell and state your name for the record, please?
Hi, my name is Igor Radakovic, Igor, last name Radakovic, and I'm the general manager of Toro Toro.
Good morning, sir. Good morning. All right, this is a fact-finding hearing, and the background for this case is that on July 31st, 2022, investigator Condon reported a patron hit another patron with a bottle in the face. The victim sustained a laceration on their chin. It's unclear when the incident occurred. MPD reported that the manager on duty was not authorized to view footage. There is also indication that the area where the incident occurred may have been unclean, but it has not been clear that the establishment knew about the incident. Now, this is a fact-finding hearing. The board has made no determination what the next step is. What we are here doing today is to gather the facts. At the end of this fact-finding hearing, the board will make a determination whether or not we will submit this case for show cause hearing, or whether or not we will make a determination that no further action should be taken. As Mr. Klein is an attorney, he's aware the board cannot order the licensee to take any specific action at a show cause, at a fact-finding hearing. The board can ask the licensee to take certain action. The licensee, however, is free to deny taking those actions but again, the board cannot order any specific actions at a fact-finding hearing because we're just gathering investigation. This is informal. None of the parties will be sworn. And so therefore, as I stated before, we're just gathering information. So we'll have Mr. Condon, he did a case report. So I'll just ask him to go through his case report. The board members can ask questions off the case report. Once Mr. Condon has presented his case report, I'll have some questions I want to ask him, and then other board members are free to ask questions, and then you'll have an opportunity, Mr. Klein, to ask questions of the investigator. That everyone now understands the process that we've been following this morning. All right, so go ahead, sir. So can you tell us what is it that you found out as a result of your investigation?
Sure, yeah. So on Saturday, July 23rd, I was able to determine that the establishment failed to observe the crime scene. They also, which also led them to destroying the evidence related to the crime scene. They also operated in a disorderly manner by allowing a female patron to get hit in the face by another female patron that led to a laceration on her left chin. And I also determined that the establishment failed to provide any video footage to the Metropolitan Police Department within 48 hours of their request at the time of the incident. On Monday, July 25th at about 2:50 p.m., I interviewed the ABC manager on duty by phone. His name was Vladimir Popovich. He stated that he saw a female walking out that was kind of tipsy looking as she was leaving, and the promoter asked her if she was okay. Basically, she said that someone had hit her on a head with a bottle, and they tried to review footage. He said he was not sure who contacted the police as it relates to the incident, but he said they reviewed footage related to the incident, but couldn't find the incident, and they said that they just couldn't see anything on the footage as it relates to the incident. He said the incident occurred between 2 and 2:30 in the morning on Saturday, July 23rd, 2022. On that same day, I interviewed at 4:50 p.m. I interviewed the responding officer, Tate Cho. Officer Cho stated that the victim was with a female friend and that female friend's boyfriend. And she said that the female friend, she started dancing with her female friend's boyfriend, and that female friend got jealous and ultimately hit her in the head with basically a bottle. He said that he assisted the victim in the ambulance. He said he wasn't sure who contacted the police, but he said that he was assisting the victim while his field training officer, Officer Givens, entered the establishment to attempt to view footage. But he stated that no footage was available for review because there was no manager available was authorized to view footage. On Monday, July 25th at about 5:25 p.m., I interviewed his field training officer, Matthew Givens. Officer Givens stated that the victim was dancing with her male friend, who was the boyfriend of another female that they were all with, and that female got jealous, hit the victim on the face with a bottle, or the head area. And he said that no footage was viewed because the general manager was not present to view any of the footage. Officer Givens stated he attempted to gather what had happened, but he said that overall it was very confusing as the story kept changing. Originally she fell, and then someone else said that she was hit in the head. But the promoter that night pointed to where the incident occurred, and he said that he noted that it was the only place within the establishment that was mopped up, wiped up, and there was no bottle, no broken bottle or anything on the ground. He said it was cleaned up, fully cleaned up. And he said that at the time of interviewing, he had yet to hear from the establishment with any footage of the actual incident. The next day, I contacted Vladimir Popovich again to make sure that he did provide footage. He said that he provided footage that night, but they couldn't find anything. And he also provided me the promoter's information. Her name was Milena Majuskovic, who was there that night. On that same day at about 3:15 p.m., I interviewed that promoter, Milena Majuskovic. She advised that as she was walking into the basement of the establishment, she saw two men basically assisting a female, and she was in visible pain. She was kind of screaming. She had told the promoter that she had been hit in the head. She contacted MPD. She called 911, but she said that the boyfriend wouldn't provide any information about the suspect. The suspect had already departed the establishment, and she said it was overall very confusing. She was kind of screaming, yelling. She was just overall in a lot of pain and whatnot. But she said the incident occurred down in the basement by the booth area near the bar. I'm sorry, near the DJ booth. There's a booth and then the DJ stand. It happened, according to her, that's where it supposedly had happened. On that same day at about 7 p.m., I visited the establishment. I conducted an inspection. I didn't see any violations with the inspection. I viewed footage from 2 in the morning to 4 in the morning. I'm sorry, 4:30 in the morning on Saturday, July 23rd, 2022. I viewed it from 2 camera angles in the basement by the DJ booth and that booth that allegedly where the incident happened. I didn't see anything related to that incident at all on the camera angle. Mr. Makanovich is who I met with to view the footage. He actually didn't know how to work the system, but he had to contact Vladimir Popovich to gather and to learn how to work the camera system. I took photos of where the incident occurred, which is attached as exhibits as well. The establishment has no security plan and no settlement agreement. And on that day, Saturday, July 23rd, I was able to determine the establishment operated in a disorderly manner. They destroyed evidence related to the incident. They didn't provide footage within 48 hours to MPD as well.
I'm confused, Mr. Condon. You said you viewed the video. When did you view when did you view a video?
So I went on Tuesday, July 26th at about 7 p.m. I went to the establishment. I looked at footage from 2 camera angles in the basement, and I didn't see anything related to the incident. I didn't see anyone struck on the head or anything as it relates to that. I saw it for 2.5 hours. I was looking at footage and did not see the actual incident.
So you're saying, so again, when did the incident occur again?
According to Vladimir Popovich, between 2 a.m. and 2:30 in the morning. On Saturday, July 23rd.
Oh, July 23rd. And so
Correct.
The first time you were able to see the video was what date again?
July 26th, 3 days later.
3 days later. And why, do you know why it took 3 days for you to see the video?
I only worked Sunday through Thursday, so I was not even working Saturday, and then I got assigned the case on Monday, July 25th.
Now, do you know why? And on the 23rd, when video, who requested video on the 23rd? Do you know?
The officer in Matthew Givens, who I interviewed, he was on scene with Officer Tate Cho, and Officer Givens requested footage inside the establishment. He said nobody was on site, and no manager that had authorized access to view footage could provide the footage to him on site.
So, do you know whether or not he ever received the video?
At the time of interviewing him on Monday, July 25th, over 48 hours, he had not heard back from the establishment. I'm not sure if it's happened after, but at the time of interviewing, no footage was provided to him.
And you're saying that, so are you aware where in the establishment did this incident occur?
Through the interviewing of everyone, Milena Majuskevic and Vladimir Popovich, the incident supposedly happened in the basement by the booth area near the DJ stand in the basement. And that's the camera angles that I requested to review because that's the information that I had as to allegedly where the incident occurred.
And were you able to substantiate that through the video that was provided to you at a later date?
No, I was not. On July 26th, I did not. I saw people dancing and normal bar activity, but I did not see anyone struck in the face.
Any questions by any board members? Are you asking a question, Mr. Short? Yes, go ahead, Mr.
Yes, I'd like to ask a question if I could. Investigator Condon, thank you for your report. And the charges today that we are investigating today for this fact finding, you stated that you talked with the police officers how soon after the incident occurred?
I talked to the officers 2 days, both officers, Monday, July 25th, 2 days after the incident. As that's the day I was assigned the case that day. I was not working the day of the actual incident.
Okay, that's clear. And so it's also your testimony that the MPD officers requested footage the same night of the incident. Is that correct?
That's correct, Mr. Short. Matthew Givens and requested footage when he went. He said that they couldn't review footage and they wanted footage of it.
And to this date, to your knowledge, has any video been turned over to MPD or ABRA?
As of Monday, July 25th at 5:25, when I interviewed him, there was none. In terms of after that date, I'm unaware if it's ever been provided after that date. But at Monday, July 25th, at the time of interviewing, no footage was provided.
To whom?
To Matthew Givens, MPD.
And Mr. Short had asked you what about to ABRA?
I went the next day on July 26th and viewed it myself, but it was MPD's request that they did not provide within 48 hours.
And so when you viewed the video, were there any spots in the club with cameras that you were unable to access, or were you able to see the whole club?
Yes, I don't know exactly how many cameras they had. I remember they had a decent amount per their camera, their screen. I viewed 2 just for one, because that's where the incident allegedly occurred, and 2, just for time purposes. I viewed 2, but if I wanted to go through the entire first floor basement, I believe they had camera footage for the vast majority of the establishment, Mr. Short.
Okay. Now, I guess what I want to ask also is who was in charge of the club that night when the incident occurred?
Mr. Vladimir Popovich was the ABC manager on duty during the time of the incident.
And there was also mentioned that someone had, that they also had a third party who was part of the management that night, or renting out portions of the club. Is that correct?
Yeah, I don't believe they rented it out. I think they had just a promoter that evening, Milena Majuskevic, and she was doing an event that night, correct?
So I guess what I'm trying to find out, was the promoter in charge of things that night, or was it under the direction of a management or ABC manager or owner that night?
It was under the direction of the establishment. She was not controlling the establishment. She was just I believe, DJing, that night in the basement.
Okay, so the person who was injured, did they ever file a report?
So her name was not in the report, the MPD report. I don't know. The suspect information is not gathered. She left the scene. So the suspect information was not given. The name of the victim was given, but no contact information for the victim. I don't know why MPD did not obtain that, or they did and did not put in the report.
Okay, thank you for your excellent report, investigator, and thank you very much. That's all I have, Mr. Chair.
Thank you, Mr. Short.
Thank you, Mr. Short. Any other questions, Brandon? Any other board members? Mr. Klein, do you have any questions you would like to ask the investigator?
Yes, I do. Thank you, Mr. Chair. Good morning, investigator.
Good morning.
So, I mean, one of the issues that you were concerned with is failure to provide video footage, correct?
That, and as well as the actual incident as a whole. But yes, they didn't provide footage, and the failure to preserve the crime scene as well was a concern, according to Matthew Givens.
Okay. The requirement is that the video be provided within 48 hours of request, correct?
That's correct.
And you were indeed provided video within 48 hours of your request, right?
I was, MPD was not.
Okay. Now, if that's the violation, it would be important to know when MPD made the request, right?
At the time of the incident.
No, I'm asking you, it would be important to note when MPD made the request, correct?
Correct.
That's an important part of, if you're contending that that's a violation, it's important to know when the request was made, right?
The request was made.
No, I'm not asking you when the request was made. I'm asking you if you agree that in looking at this issue, it's important to know when the request was made and to note when the request was made, correct?
That's correct, yes.
All right. So looking at your report, can you show me where it is you noted when MPD made a request for video?
MPD told me, Officer Givens told me he made a request at the time of the incident, which according to the CCN report is 2:45 to 3 in the morning.
You didn't answer my question. My question to you is, where in the report, we agree that it's important to note when the request is made so that we can establish whether the video was provided within 48 hours, correct?
That's correct.
All right. So where is it in your report? Look at your report and tell us where it is that you noted a request for video was made.
I did not specify it in the report, but he told me that on the phone that at the time of the incident, when he was there, he went inside the establishment to look at footage and no one was there to provide the footage.
But you didn't put that in your report, even though we had.
I put that in the report that he went into the establishment and was trying to find video footage.
All right. Now.
And he said it was not available. And he said it was available, according to Vladimir Popovich, it was available in the upcoming week.
Okay.
So that would be the time of the request. And according to the time, I was going by the CCN report, MPD's report, as to the time of the incident, that's when we can assume he was making that request.
Well, but you're an investigator. You're doing a report. You're doing an investigation, and you're contending that, and you've argued, and I don't know why, that this licensee is in violation of at least 3 sections of the EBC statute.
Right.
So I'm not really sure. May I finish, please? I'm not sure why you're arguing that. It seems to me your job is to investigate, but that's what you've done. You've come up before the board, and you're arguing that they're in violation. And we agree that one of the components of a violation of failing to provide video footage is noting when the request occurred, correct?
That's correct, Mr. Klein, but I feel that I have adequately shown when the request was made, even though it's not
Now,
specifically stated in my
your
report.
discussions with both the DJ/promoter and police, it's pretty clear there was quite a bit of confusion as to what went on, correct?
That is correct.
All right. Now, you also said pretty clearly that it's your contention that evidence in the control of the establishment was destroyed. What evidence are you contending was destroyed?
According to Matthew Givens, Officer Matthew Givens, he went into the establishment, asked where the incident occurred. He was pointed to the downstairs booth area. He said it was the only area within the establishment that was wiped up, cleaned up. There was no bottle on the ground, nothing, and it was the only thing that he said was cleaned up. That's according to Officer Matthew Givens, who was on scene at the time of the incident.
But since that time, you had an opportunity to view a video of that area of the establishment, correct?
That is correct.
And you didn't see any incident in that area, did you?
That is correct.
So I'm going to ask the question I asked before now in light of that. What evidence do you contend was destroyed?
I'm going by Matthew Givens' verbal statements, and that's as ABRA investigates, we rely a lot on MPD and what their statements say. So According
And
to all
you
the
give that
confusion,
more credibility than the video that you watched with your own eyes?
well, according to you, Mr. Klein, as well, there was a lot of confusion, and maybe there was confusion that advised Mr. Officer Matthew Givens of where it happened, but he said that there was an incident that occurred, and he said it was the only area that was cleaned up, according to Officer
All right.
Matthew Givens' statement.
So let's assume that's correct. Your statement was not that anything was cleaned up. You said evidence was destroyed. What evidence is it that you contend was destroyed?
According to Officer Matthew Givens, the incident happened downstairs, and it was the only area cleaned up, the booth area by the DJ board. So that would be the evidence that would be destroyed if they had only cleaned up just the remnants of the assault.
So what was the evidence? You keep telling me what
A
Givens
broken
told
bottle.
you, but
He didn't say any. He didn't specify evidence. He said there was only area that was wiped up. He said the floor was mopped and the table was cleared. It was the only area within the establishment at that time that was mopped and cleaned. What evidence? I don't know. It could be blood, broken bottle. I'm not sure. But he said it was mopped. The floor was mopped, and he said overall it was cleaned up.
okay. But in your view of the video, there wasn't any incident that you observed that would have caused any blood or anything else to be there, was there?
That's correct. From those 2 hours between, I'm sorry, 2.5, 2 to 4:30 on Saturday, July 23rd, from those two angles, I did not see anything. That's correct.
All right. Thank you. I have no further questions.
Any follow-up questions by the board members? I guess, but Mr. Khan, who told you to look at? Who told you that it appears that? Who gave you a location of where the incident might have occurred?
The promoter, Milena Majuskovic, as well as Vladimir Popovich, stated, according to Vladimir Popovich, it happened downstairs near the bathroom area, which presumably is near the DJ booth and the booth there, and that's also where Ms. Majuskovic provided the information. She was the first one to assist the victim from the establishment.
And you reviewed the video, but you did not see when you reviewed the video, you did not see any incident. Is that correct?
That's correct. Yes.
Did there appear to be any blind spot in that area? That was not captured by the camera.
I didn't see any blind spots. No, I did not.
Okay, fine. Thank you. All right, Mr. Klein. On
Yes,
behalf, I mean, either you or your client can inform us. I mean, it's like, what happened that night? These are the questions that I'm curious about. I have a bunch of questions that just generally let you know what my concerns are. What happened that night? What's the establishment's process for preserving a crime scene? What's the establishment's process for turning video over to either ABRA or MPD? What happened? And if this incident occurred, why was it not on camera?
Okay, so as the report states on its face, there was a lot of confusion as to exactly what occurred or what did not occur. There's not a single person that witnessed what's at least one person contends happened, which that this woman was struck. So it's really unclear. If you look at the report on its face in terms of the interviews, there's no clarity in terms of what happened. If it's not on the video, then there certainly appears to be some question as to exactly what happened. In our investigation, we haven't been able to discover anything else in terms of what the incident was, how it occurred, what happened. I think, look, the board has heard many cases in establishments. Sometimes things happen. This was not a situation. It appears to be, at least according to the only witness testimony we have, which is from the victim and a friend who refused to give their names and refused to file a complaint and a number of other things that call things into question. But a dispute among two women and a man, one of the women was the man's boyfriend, and he was dancing with the other woman, and according to them, that's what happened. We don't have any explanation as to why that's not in video, if indeed that is what happened. As the investigators pointed out, and as my client has informed me, there is coverage, adequate coverage of the public areas of the establishment, and nothing was noted in terms of anything happening. So in terms of the incident, we know as much as is in the report. You will see in the report that there were efforts to get medical aid to the person that was in distress, and that was done and that was handled. The video, according to our witnesses, was made available that night. And it certainly, at worst, was made available within 72 hours to the ABC investigator, and certainly was made available to him within 24 hours of his request. So I don't think we see any major failures here in terms of the establishment's responsibilities. And in terms of a crime scene, as Mr. Chair, you said at the outset, one only knows not to clean up a crime scene if they know it's a crime scene. And at this point, even after the fact, there seems to be insufficient evidence that this was a crime scene because there's nothing on the video. So I think in sum, what we have here is just one of these incidents that occurs. The person that was injured was attended to. The video was provided. One can argue that it was a day late in terms of MPD. It was made available to the investigator. It's interesting that there's no, we hear, well, MPD didn't have it. I don't know why Abbott wouldn't have immediately turned it over to MPD if that were an issue. But the fact of the matter is there's nothing to see. I mean, there's nothing on the video. So what happened here, we're not exactly clear. So I don't know that we see any failures. I think the video was promptly provided. We are looking at the video procedures to make sure there is no confusion in the future in terms of making sure that it is available within 48 hours and that staff is aware that even if there's no one there that evening, that MPD or an Abbott investigator should be advised that that they will be contacted the next day and provided access to the video. We think that addresses the only issue that we see with respect to this matter. And we would request that the board look at the report and what's contended here, and that there was confusion in terms of nobody really knows what went on, and follow-up was difficult because of the refusal of the parties to give their identities or the identity of the person that left that apparently was the perpetrator.
Mr. Klein, approximately how many cameras does this establishment have? Are you aware?
I'm going to punt that one to Igor. Igor, how many cameras are there?
Hi, around 30.
So you have there around 30 cameras in the establishment. And Mr. Klein, shouldn't your client be concerned that an incident occurred inside of the establishment and you have no video footage of this incident?
Well, we don't know. We don't know what occurred. I mean, to presume that an incident occurred because of the statement of a person who refused to identify the party involved, I think is suspect. I mean, we just don't know what went on. And video was reviewed and nothing was found. So I understand if there were witnesses before us who said, yeah, we saw it all and we don't have it on video, I would understand the board's concern. But absent that, simply based upon the word of a person who is so sketchy they won't even give the name of the person involved, I really have to question what it is, what standard the applicant is being held here to.
I'm sorry, who's asking a question? Mr. Grandis? Yes, sir.
I apologize. It's your answer. He just made a statement. I just wanted to get clarification, but I can wait till you're done. I apologize.
Go ahead, Mr. Grandis. You can ask whatever question you want to ask.
Good morning, Mr. Klein. It's
Good morning.
a pleasure to have you here to give us your client's understanding of what occurred. I'm going back to the testimony of our investigator who cited the investigation report, and it says
Hold on, Mr. Grandis, hold on 1 minute. Mr. Radovic, are you driving, walking? What are you doing, sir?
I mean, like walking back and forth in one place.
I need you, sir, to be stationary, sir. It is somewhat distracting. So I need
Okay.
you to be stationary for the duration of this matter.
Okay.
Okay, sir?
Yeah.
All right. Thank you. Go ahead, Mr. Grandis.
Thank you, Mr. Chairman. Mr. Condon read excerpts of the investigations report, and in it, he cited the promoter originally stated that the female fell on her own. There was no general manager present who was authorized to view the security camera footage, but the promoter for the evening pointed to where the incident had occurred. So I think it's clear that the incident occurred inside the premises. And I think you were not clear that you had heard that. Is that right, Mr. Klein?
There are other statements that said it was overall confusing as she heard many different stories about what had happened. So
That's not what, Mr. Klein. I'm going to the direct statement of the promoter. He or she does not seem confused. So yes, other people may be confused, but this particular person who is stated in the report clearly said that he could point out where the incident had occurred.
Are we talking about the same person? Are we talking about Melina Mijuskovic?
I don't know. I'm reading the language of the promoter.
Right, as am I. On page 2, 5 lines from the bottom, Ms. Mijuskovic stated it was overall confusing as she heard many different stories about what had happened.
That's different than where it happened. Okay,
well,
there may be confusion. There may be confusion.
She doesn't say that she saw it. She says that she saw a girl being held by two men. So I think that if we had
You're being selective, Mr. Klein, and I don't want to be arguing.
Selective, Mr. Grandis, with all due respect.
Mr. Klein,
You're saying
I'm done on this
question. It happened over there, and the fact of the matter is, she says that she heard many different stories as to what happened. Certainly, one of them was likely it happened over there. But in terms of what happened, we don't have a clear story as to what happened.
Thank you, Mr. Klein. Thank you, Mr. Chairman.
All right, thank you, Mr. Grandis. Any other questions by any other board members? Mr. Klein, is this, would your client consider, does your client have a security plan?
No, they do not. And we would, and I'm sorry that I didn't even get there because we never got there, but we would certainly agree that it would be appropriate that the establishment create and file with the board a statutory compliant security plan.
But can the establishment file such a plan with the board within the next 30 days?
Yes, sir, absolutely.
All right, well, thank you. Now, it's my understanding, so the establishment is voluntarily agreeing to file a security plan with the board within the next 30 days. Okay.
Yes, sir, we're very clear on that.
No, I'm not sure what type of training is that what type of training is provided to staff to ensure that over-service doesn't provide? Are you aware of that, or can your client provide that information?
Igor, you can provide that.
Yes, so all the managers are TIP certified, or the late night managers, they finished the security training provided by late night agency I just need to remember the name. And then
Was it
also,
Robert Smith, Igor?
yes, correct. Robert Smith, Slide 9 Agency. And we do tip certified trainings for our bartenders as well. Now,
Now, what night of the week was this? Did this occur? Did this incident occur? Specifically, what night?
Friday night, Saturday morning.
Friday night, Saturday. So, what's the capacity of the establishment, and approximately how many security personnel do you have during this period of time?
Igor?
the capacity downstairs is 180. And we do have an establishment 8 security, and then after 8 security.
So you're saying 8 security for the 200 downstairs, or how is it? How many floors is the establishment?
There is a ground level, and then from the ground level you go into the basement, and the basement is where the dance floor is and the DJ booth. So the capacity of downstairs is 180.
180, and so you're saying that there's approximately 8 security personnel for the 200, which is the capacity of the from your certificate of occupancy.
Yes.
I'm sorry, any other questions by any other board members?
Mr. Chairman?
Yes, Mr.
At this time, have I missed the opportunity to ask a question of the investigator?
You can ask a question of the investigator, Mr. Grandis.
Investigator Condon, thank you for your testimony today and the presentation you made.
Sure, thank you.
You made a statement that you did go back and were able to view footage of various cameras in the establishment, but that you did not see footage of the incident itself.
That's correct, Mr. Grandis. I saw video footage from 2 angles where the incident allegedly occurred, and I did not see anything in those hours. I mean, there was a decent amount of people in the footage, and I didn't see anyone struck in the head by any bottle. I didn't see anything like that from those 2 angles.
Well, I believe the owner testified just now that there are 30 cameras in that establishment. That's what I think I heard. What I just heard you say, am I correct that you stated that you believe that you were looking at a camera that was directed, or cameras that were directed at that particular location near the DJ booth?
That's correct, Mr. Grandis. Yep, 2 angles that was showing what I believe correct. And I also visited the establishment, so I did verify it looked to be the area where it allegedly occurred.
Did you look at the timestamp of those to see if perhaps the camera maybe malfunctioned, or maybe there was some tampering that because of the exact time that footage wasn't available?
I didn't see any, Mr. Grandis, of any tampering. I couldn't see anything. There was a decent amount of people in that basement standing together and whatnot. Could something have happened? Of course something could have, but I didn't see anything on the footage. But I didn't view any other footage.
Would you think the investigators would be able, if they go ahead and voluntarily do the security plan, because 30 cameras sounds like a sufficient number for a basement and a first floor? Would you believe you all have expertise to help maybe make sure how they're angled and where they're located? Because it does seem that an incident did occur, and perhaps maybe changing the angle of a camera would be helpful to the owner as well as to investigators.
Yes, that's something that would definitely be helpful as well. And I think there were, I believe Mr. Klein or the owner said there was 8. Is that correct? 8 security present that night? Was it 8?
Right.
So, I don't know, maybe more security guards present to really notice, so they could be like, this is exactly where it happened, because nobody other than the promoter really was aware of the incident when it really occurred, which the promoter is not an employee of the establishment. So if that
How many times did you visit this facility?
just that one time on Tuesday, July 26th, about 7 p.m.
7
But
p.m. And were they open?
Yes, they were open. The basement was not in use at that time. It was so basically on Friday, Saturdays. What I learned through Vladimir Popovich as well as Zarko Makanovich is Friday, Saturdays they do kind of like I want to say a nightclub, but they turn it more into a nightclub. But on weekdays, it's closed by 8 p.m. It's very restaurant like. So when I was there, it was very restaurant like because it was a Tuesday night.
So from my understanding, if I'm understanding you correctly, the basement level is not used except Fridays and Saturdays.
I believe so. Yes.
Okay. And the area that is used, which would be the first floor, is performing like a CR, which is what their license says. And they have a menu, and that they actually close early. Are they open for lunch? Are they open for lunch? Would you know?
I'm not sure, but I did verify on Friday, Saturdays. I made sure that their kitchen is open, so they do serve food on those Friday and Saturday till at least 2 hours before closing. So I did verify that. I think they serve small plates, so they're still cooking and whatnot as they're required by their CR.
I want to thank you for your testimony. Thank you very much. Thank you.
Thank you.
Any questions, Mr. Klein, based on those questions that were asked by Mr. Brandis?
No, I don't have any. Thank you.
Any questions by any other board members? Any final comments you want to make, Mr. Condon?
No, I think I think a security plan is appropriate, but I think the big thing too is the concern too is that the only person that really kind of saw what happened was not even an employee of the establishment. No security noticed it. None of the 8. Ms. Makanovich, as I said, I don't believe is an employee, so I think that's definitely a concern. That the only one that noticed it is an employee, and the only one that called 911 is a non-employee.
Thank you, sir. Mr. Klein, any final comments you want to make?
I mean, yeah, I just have to say that. And I mean, it's not clear that she saw it from the report. It seems to reflect that it's based upon what was told to her by others. She never says, and if that's the information that was available, it should have been fleshed out in the report. I mean, there isn't any information here that she saw it. So it's really unclear as to what happened here. We agree. It's troubling that someone would get injured in the establishment and that they would claim that this is what happened, but somehow nobody noticed it and it's not visible to anyone. Yeah, we find that very troubling. I'm not sure what the solution to it is, but I would submit to the board that the fact that those involved refused really to cooperate in any sort of investigation tells some sort of story. I don't know what it is, and I don't pretend to know what it is, but if someone were injured in an establishment, it would seem to me that they would cooperate with those that were investigating. They didn't cooperate with MPD really, and wouldn't provide the information as to who was involved. It's all very suspicious, not on the part of the establishment. I think the establishment has been forthcoming about what it knew, and I think that Mrs. Majeskovic's statement that it was overall confusing, as she heard many different stories about what happened, means that we don't really know what happened. And I'm not sure we even are sure where it happened. And maybe if one spent hours and hours and hours looking at the tape from 30 different cameras, maybe we'd find out. But in the absence of that, we would ask the board not to assume the worst, not to speculate, that there was a reasonable effort to cooperate both with MPD and with the investigator, and that the big issue, which was someone was injured, that was attended to rather quickly. Ambulance was called and they were there. However, the applicant will, as we've promised to you, submit within 30 days of a security plan so that it is clear and the board is clear as to how an incident like this might be handled in the future.
Thank you very much, Mr. Klein. And I am concerned, and you raised the same concern, that an incident did occur. And although the establishment has over 30 cameras, it's not apparent that this was captured by cameras. So this is something that the establishment needs to be concerned about. All right. The board will take this matter under consideration, and we will make a determination whether or not we will refer this matter to the Office of the Attorney General if we determine that there is some legal violation, or no further action if the board determines that no further action is necessary. But as you stated, the one agreement that we do have here is that your client will provide to the board within the next 30 days a legally compliant security plan. All right.
Yes, sir.
Thank you very much. Have a
Thank
great
you.
day.
Thank you, Mr. Chair, members of the board.
Thank you.
Thank you. All right. We're now at the end of our morning calendar. So I'm going to do some of our agendas. So the first agenda that we're going to do our licensing agenda. The first matter on our licensing agenda is a review request to remove the license from safekeeping to reopen in mid or late October. This is for Russia House, license number 080952. I make a motion that we approve this request. Is there a second?
Grandis will second.
Mr. Grandis and Ms. Crockett is second. The motion will now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Grandis and I agree. The matter passed 5-0. Number 2 on our licensing agenda, review application to extend safekeeping of license. This is for iCaroline license number 116082. I make a motion that we approve this request through March 31st, 2023. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 3, review application request to extend safekeeping of license. This is for JG 2325 18th Street LLC, trade name to be determined, license number 116507. I make a motion that we have a fact finding here in this matter. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Grandis and I agree. The matter passed 5-0. Number 4 on our licensing agenda, review application to extend safekeeping of license. This is for Cork and Bottle Wine and Spirits, license number 089012. I make a motion that we approve this request through March 31st, 2023. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Grandis and I agree. The matter passed 5-0. Number 5, review application to extend safekeeping of license. This is for Social Beast. Formerly, the license number is 120780. I make a motion that we approve this request through March 31st, 2023. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short.
Short, I agree.
Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 6, review application to extend safekeeping of license. This is for Mejalo Cachina Mexican Levore. The license number is 115103, and the new license would be 121622. I make a motion that we approve this request through March 31st, 2023. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 7, review application for a change of hours to open on Sundays. This is for A1 Wine and Liquors, license number 116790. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. We now move to our supplementary license agenda. The first matter on our supplementary license agenda is a review request to change the hours of the entertainment endorsement to match the approved settlement agreement and change hours of operation. This is for TRAP 99, license number 116883. I make a motion that we approve this request. Is there a second?
Ms. Crockett
Ed
seconds.
Grandis will second.
Ms. Crockett and Mr. Grandis have seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 2, review request to increase capacity from 206 to 298 in accordance with the updated certificate of occupancy. This is for Lost Society, license number 083420. I make a motion that we approve this request. Is there a second?
Edward Grandis will second.
Mr. Grandis has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 5-0. We now move to the board's temporary license and one-day substantial change docket. On this docket, there are 19 applicants' requests for licenses. I will review all 19 names, and at the end of I will give you the name of the applicant, the type of license that's been requested, the date for the event, and the license number. And at the end of the list, I will make a motion that the board grants all of these applications. So the first request, a request made by Rita Santos. This is for one-day license class F. This is for a social alumni event on September 28th, 2022. There's license numbers 122150, 30 attendees, 1 security guard. Number 2, a request from Peter Torpre, a one-day license class F. This is for an Oktoberfest fundraiser. This is on October 22nd, 2022. The license number is 122651, 100 attendees, 2 security guards. Number 3, a request from Adam Frank, Tacoma fundraiser. This is on October 1st, 2022. The license number is 122648, 400 attendees, 10 security guards. Number 4, a request from Denise Claiborne, a one-day license class F, 90th birthday celebration. This is on September 30th, 2022. The license number is 122645, 200 attendees, 4 security guards. Number 5, a request from Alexandria Davis, a one-day license class F, private dinner, September 30th. The license number is 122663, 15 attendees, 1 security guard. Number 6, a request from Daniel Hanfman, Hanfman, a one-day license class F, a wedding. This is on November 25th, 2022. The license number is 122666, 110 attendees, 2 security guard. Number 7, a request from Tobias Harkle Road, Harkleroad, a one-day license class F. This is for a fundraiser. This is on October 6, 2022. The license number is 122699, 90 attendees, 2 security guards. Number 8, a request from Margarita Broinstein, Bronshstein. This is for 1-day license class F. Religious celebration, October 17th, 2022. The license number is 122690, 200 attendees, 4 security guards. Number 9, another request from Margarita Broinstein, Bronshstein, a 1-day license class F. This is the Jewish holiday Purim celebration. This is on March 6, 2023. And it's on the license number is 122691, 200 attendees, 4 security guards. Number 11, a request from Lana Mahmoud, a 1-day license class F, a concert, October 6, 2022. License number is 122695, 350 attendees, 6 security guards. Number 11 is another request from Lana Mahmoud, a 1-day license class F, concert on October 14th through the 15th through the 16th. The license number is 122696, 350 attendees, 6 security guards. Number 12, another request from Lana Mahmoud, a 1-day license class F, a concert, October 22nd, 2022. The license number is 122694, 350 attendees, 6 security guards. Number 13, another request from Lana Mahmoud, a 1-day license class F, a concert. This is October 25th, 2022. The license number is 122697, 800 attendees, 10 security guards. Number 14, another request from Lana Mahmoud, a 1-day license class F, a concert. This is on October 27th and October 28th, 2022. The license number is 122692, 350 attendees, 6 security guards. Number 15, another request from Lana Mahmoud, 1-day license class F, a concert on October 31st, 2022. The license number is 122698, 350 attendees, 6 security guard. Number 16, another request from Lana Mahmoud, 1-day license class G, concert, October 22nd, 2022. The license number is 122693, 800 attendees, 10 security guards. Number 17, a request from Patrick D. Batista, an LGBTQ dancing. This is on October 15th, 2022. The license number is 122674, 200 attendees, 4 security guards. Number 18, a request from Andrew Eisenhower, EISENLOHR, a 1-day license class G, a wedding. This is on October 8th, 2022. The license number is 122662, 100 attendees, 2 security guards. And number 19, a request from Brightwood Pizza and Bottle, a 1-day substantial change. The 1-day substantial change is for them to use their license off premises at the park at Walter Reed, 1010 Butternut Street Northwest. The date is October 8th, 2022, with a rain date of October 9th, 2022. The license number is 102866, and the substantial change license number is 22SC00981. They expect 500 attendees and 8 security guards. I therefore make a motion that ABC Board grants these licenses. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. We now move to the license and administrative docket. This is the last. These are the applications where this is the last stage in the agency issuing the licenses. So I'm going to name, there are 13 applicants on this list. I will read the names of 13 applicants, the type of license and class and category. And at the end of the list, I will make a motion that the ABC Board authorizes the agency to issue these licenses. The first applicant is Thompson, Washington, D.C., Anchovy Social, Milena Mayor. License number is 114613. They are Retail SE Hotel. This is a letter to request to remove the entity from the license. The entity that's been removed from the license is 215 Tingy Street Southeast F&B Management LLC. Number 2, DC Food Market license number 106962, their retailer B change of hours application. Number 3, Liberty Le Grand Restaurant license number 109012, their retailer C restaurant trade name change application. The new name is Le Avant Garden. Number 4, The Saga license number 122095, retailer C restaurant trade name change application. The new name is The Saga Quadrant Bar and Lounge. Number 5, we have a request from Joel Ellenboss. There, he's requesting a personal importation permit application. This will be granted, and the license number is 22 IMP 00027. Number 6, a request from Umaya, UMAYA, license number 094099, their retailer C Tavern stock transfer application. Number 7, a request from House Bar, license number 119114. They are retailer A liquor store stock transfer application. Number 8, Bunker Nightclub, license number 122706. Retailer C nightclub transfer with sale application. Number 9, Air Restaurant, license number 117404. Retailer C restaurant stock transfer application. Number 10, Clubhouse, license number 122711. Caterer's license, new ABC license application. Number 11, Vintage Views Bar, license number 122126. Caterer's license, new ABC license application. Number 12, Lucky Bar, license number 020234. Retailer C Tavern, stock transfer application. And number 13, the Looking Glass Lounge at Temperance Hall, license number 074765. They are retailer C Tavern, stock transfer application. I therefore make a motion that ABC Board authorizes the agency to issue the license for these establishments. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. The board is now at the end of its morning calendar and agenda. I'd like to thank all members of the public who participated in this process this morning. The board then will be in recess until 1:30 p.m. I now ask all board members to return to executive session for further action. Thank you very much. Have a great morning. Good afternoon, everyone. We're on the record. Good afternoon, everyone. My name is Donovan Anderson. I'm chairman of the ABC board. Joining us this afternoon are four other members, I apologize, Mr. James Short, Ms. Rafi Crockett, Ms. Jenny Henson, and Mr. Edward Grandis. The board has 5 members in attendance this afternoon, and that constitutes a quorum. Before we get underway with this afternoon's calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 4 cases scheduled for this afternoon. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance in the hearing, please submit them during using the question and answer feature. All right, the first matter on our afternoon calendar, it's the board announcement regarding the medical cannabis facility selection. Today, the District of Columbia Alcoholic Beverage Control Board announces the results of the 2022 medical cannabis facility application process. By way of background for both the process and the timeline, the board provides the following. On March 3rd, 2021, the board announced an open period by which persons and entities could submit letters of intent to qualify for and obtain approval to submit an application for an available medical cannabis facility registration in the district. Available registrations included 2 testing laboratories, 1 dispensary for either wards 3 or ward 5, and 2 cultivation centers for any ward excluding ward 5. The board began accepting letters of intent on March 22nd, 2021, and set a deadline for May 21st, 2021. Only those persons and entities that filed timely letters of intent were eligible to submit an application for a medical cannabis cultivation center, dispensary, or testing lab. Following the LOI phase of the process, the board started the application period on November 29th, 2021, and set the application deadline for March 28th, 2022. Based upon the limited number of available registrations, it was not possible for the board to approve all timely submitted applications. After the application deadline passed, applications were reviewed and scored by a multi-agency selection panel. The selection panel was comprised of ABRA, DC Health, DCRA, DFS, DGS, DOEE, and OAG. Upon the panel's completed review, scores and comments were provided to the board to evaluate each application. The board has now reviewed the scores and findings provided by the selection panel and adopts them without modification. Pursuant to 23 DCMR section 5402.13, the board adopts the selection panel's reports and findings and announces the following selection results. First, due to the failure of any application for a testing laboratory to achieve a high enough score, no testing lab registrations are being issued at this time. Second, the 2 selected cultivation center applications are the ones filed by Renee and Andrea Health LLC and Bouquet Labs DC LLC. Third, the selected dispensary application is the one filed by Bouquet Labs DC LLC. The board also adopts the recommendation of the selection panel for those applications that were disapproved. With respect to the applications filed by Rooted Therapeutics, Eluxo LLC, and Amite Enterprises, the record will reflect that board member Crockett has removed herself from the selection process regarding those specific applications. The board further notes that all applications will receive applicants will receive decision letters explaining the specific reason for their application, that their application was either approved or disapproved, as well as a copy of the final score rankings for all applicants and the individual score sheets related to their specific applications. The board emphasizes that today's decision does not prevent or otherwise prejudice unsuccessful applicants from seeking to apply for a medical cannabis facility registration with ABRA in the future. For additional information, the board directs applicants and members of the public to ABRA's website, where additional documents and information related to today's decision and the selection process have been posted. Thank you. All right, let's move to our legal agenda. The first matter on our legal agenda is a review of a settlement agreement dated September 5th, 2022, between the Citizens Association of Georgetown, the Advisory Neighborhood Commission 2E, and Villa Yara, license number 121278. I make a motion that the board approves this agreement. Is there a second?
Mr. Short, I second.
Mr. Short and Mr. Grandis is second. The motion will now have a roll call vote. The motion, Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Grandis and I agree. The matter passed 5-0. Number 2, review of the motion to dismiss protest dated September 19th, 2022, filed by Lidell USA Operations, license number 119890. The board will hold this matter in abeyance for further information from the ANC. Number 3, review of the opposition to the motion to dismiss protest dated September 19th, 2022, filed by ANC 7B in the Lidell, license number 119890. The board will also hold in making a decision in abeyance until further information is provided by the ANC. And number 3, review of the opposition to motion to dismiss. Number 4, review of reply to opposition to dismiss motion. The protest dated September 26, 2022, filed by Lidell US Operations, Lidell, license number 119890. Again, the board will hold this matter in abeyance until further information provided by the ANC. Number 5, review of request to reinstatement of dismissed application dated September 16th, 2022, filed by EMB International Trade Name Cafe Georgetown, license number 106108. I make a motion that we deny this request. Is there a second?
Mr. Short, I second.
Mr. Short, a second. The motion will now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 6, review of the motion to continue dated September 3rd, 2023, filed by Assets, license number 113585. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Grandis and I agree. The matter passed 5-0. Number 7, review of the consent motion to continue dated September 26, 2022, filed by Empire DC, the Empire Lounge, license number 110702. I make a motion that we approve this request. Is there a second?
Ms. Crockett
Grandis.
seconds.
Ms. Crockett and Mr. Grandis have seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 8, review of the request for off-site storage of records dated September 26, 22, filed by Blues Alley Jazz, license number 076996. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passes 5-0. We now move back to our calendar. The first, we now have a show cause hearing on our calendar, case number 19251-00157, assets license number 113585. This case has been continued to November 2nd, 2022 at 1:30 p.m. The next case in our calendar is case number 22 PRO 00064, El Centro DF, license number 604. Mr. Oriana, can you please elevate the rights of the licensee and the protestant in this case, please?
Don Johannes, your access has been elevated. Karen Cruz, your access has been elevated. Kevin Kozlowski, your access has been elevated. Makia Nelson, your access has been elevated. That is all, Chairman.
Thank you very much.
Good afternoon.
Good afternoon. Good afternoon. Let me wait for the other parties to.
Good afternoon.
Hold on 1 minute, please.
Good afternoon.
All right, let me see. All right, could the parties introduce themselves? So go ahead, Miss. Let me have the representative of the licensee.
Sidon Johannes here on behalf of the licensee. That's SIDON YOHANNES.
And let's also have the protestants. It's Citizens Association.
Karen Cruz, KAREN CRUSE, representing CAG, Citizens Association.
And, the group of five or more.
Good afternoon, Kevin Kozlowski, KEVIN KOZLOWSKI, on behalf of the group of five citizens.
Good afternoon, everyone. This matter was scheduled for a protest hearing, but it's my understanding that there's some preliminary matter that needs to be discussed. Ms. Johannes.
Yes, the parties this morning have reached a settlement in this matter and are requesting at this time that the board schedule this matter for another week just to give the parties time to put this in writing, finalize it, and just sign off on it by the appropriate parties, by the appropriate individuals.
Thank you for the representation, Ms. Johannes. Ms. Cruz.
We support that. We'd like to get a settlement.
Kozlowski.
Yes, sir. We agree. We consent. We have a settlement reached. We just need to memorialize it, and the continuance will allow us to do that.
Thank you very much. With that, then I make a motion that the board grants the parties a 1 week continuance for them to bring for them to sign a settlement agreement on this matter, so far as to continue this matter for a week. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
Grandis.
Edward Grandis, I agree.
Agree. The matter passed 5-0. I would like to thank the parties for coming to an agreement in this matter, and you're not therefore granted a 1 week continuance for the settlement agreement to be provided to the board for our consideration and then approval on our legal agenda. Thank you very much and have a great week. Thank you.
Thank you, Mr. Anderson.
Thank you very much.
Yep. All right, the next case in our calendar It's another protest here in case number 22 PRO 00053 VIP Lounge, license number 119913. Mr. Oriana, can you please elevate the rights of the licensee in this case, please?
Commissioner Eric Bena, your access has been elevated. Jovan Miller, your access has been elevated. Pearson Stockline, your access has been elevated. Richard Bianco, your access has been elevated. That's all, Chairman.
Thank you. Okay, all right, good afternoon, everyone. So let me have the parties introduce themselves for the record. Let's start with you, Mr. Bianco.
Good afternoon, Mr. Chair and members of the board. My name is Richard Bianco, Richard Bianco. I am counsel for the applicant. And with me, I have DeReggie Daniel, and he owns the applicant entity. And I can have him introduce himself and spell his name.
Yeah, please have Mr. Daniel, please spell and state your name for the record in your relationship, please.
Good afternoon, everyone. My name is DeReggie Daniel, Dereje. Last name is Daniel, Daneale.
What's the relationship to this establishment, sir?
With owner.
Who's representing the ANC?
That's me, Chairman. My name is Eric Bena, ERICBEHNA for ANC 1B.
And the association?
Yes, Mr. Chairman. Pearson Stockline on behalf of Westminster Neighborhood Association, spelled Pierson, last name Stoecklein.
Thank you, sir. All right. This is I think we have an investigator there. Can the investigator please identify himself for the record, please?
Good afternoon, Chairperson. Investigator Jovan Miller, Jobanmiller.
Good afternoon, sir. All right, this is a protest hearing, and the purpose of this protest hearing, it's a substantial change application. So it's a class change from a retailer CR to a retailer CT, and change of hours, sales, service, and consumption, live entertainment, and to increase the total occupancy load from 75 to 185. Those are the protest issues today. Prior to starting the hearing, Mr. Bianco, are there any preliminary matters that you need to bring to the attention of the board?
None from the applicant.
The ANC, any preliminary matters? Mr. Boehner, any preliminary matters you need to bring to the... Mr. Boehner?
No preliminary matters.
Mr. Stockline? You're on mute, sir. Any preliminary matters?
Yes, Mr. Chairman. Can you hear me now?
Yes, I can hear you. Any preliminary matters you want to bring to it?
Yes, Mr. Chairman. For reasons that are not known to me, the WNA was not served with a PIF or exhibit list prior to this proceeding. And so I would ask that the chair restrict the applicant's case presentation to solely oral testimony of the applicant. In other words, we would object to any other witnesses or exhibits as improper because they were not properly noticed.
Mr. Bianco?
Well, it's not the case. We served PIF, we served all of our exhibits. Receipt was acknowledged by the agency. And I can, let's see if I can pull up the email for this. So looking at an email dated Wednesday, 9/21, sent to Abra Legal, Danette Walker, Martha Jenkins, Dan Orlasky, and Lynn Johnson. See attached the applicant's PIF in the above referenced matter. Below is a link to the exhibits, which are too large to attach as an email.
I'm sorry, who were the names again you sent it? Who were the email directed to, Mr. Bianco?
So the email was directed to Danette Walker, who's with the board, Martha Jenkins, counsel to the board, Abra Legal, which is the appropriate filing email address, Dan Orlasky, who is the ANC commissioner for SMD 1B02, designated as a representative in this case, and Lynn Johnson, who is designated as a representative for WNA in this case.
And how do you know that Mr. Johnson was designated as a representative in this case, sir?
From the protest letter.
From protest letter. Mr. Stockline, it's my understanding that from protest letter that Mr. Johnson was designated as the representative for WNA. Is that correct, sir?
In the protest letter, we indicated that there were 3 co-representatives and that I was and am the primary designated representative for the WNA.
But
in prior proceedings, which I would add is consistent with all of the instances in which WNA has appeared before this board before, and in fact interacted with Mr. Bianco. So this should come as no surprise.
So who is Lynn Johnson, sir?
Mr. Johnson is the president of the WNA.
He's the president of the WNA, and was he designated as one of the representatives for the WNA?
He was. However, we requested in our protest letter explicitly that all materials, information, correspondence, etc., as seems to be the sort of common practice in these proceedings, that all of that flow through me and be directed to me. I'm not sure why it's not especially hard to copy an email address, so I'm not sure why that wouldn't have happened in this case. And I've confirmed with Mr. Johnson, at least to the best of his knowledge, though I don't manage his email, that I confirmed with him that he indicates that he did not receive the information.
Well, Mr. Stockline, the protest letter that came into our agency on June 22nd, 2022, It was signed by Mr. Johnson, it was signed by Mr. Johnson, who's the president of the WANA. It has his email address, it has Daniel Freeman, and it has your email address, sir. Mr. Bianco, he sent, the protest letter was sent to, one of the designated representatives of the WANA. So therefore, there is no reason for me to prevent them from, there's no reason for me to not allow them to rely on documents and witnesses. And in this particular case, I don't think that it's relevant because I'm not sure if, I know that, I'm sorry, Mr. Bianca, how many witnesses do you plan, what witnesses do you plan to call, sir?
Mr. Anderson, I think I'm going to be able to make this quick. I have one witness in reliance on the WNA and ANC's joint PIF, which affirmatively represents that they are calling 0 witnesses. So I was able to streamline my case significantly.
And who's the witness who's the witness that you would be calling, sir?
DeReggie Daniil.
Who's the owner? And I believe that Mr. Stockline would not, at least the motion that you raised earlier, he did not object to his testimony. But I think in this particular case, I'm going to overrule. I'm going to deny the motion because just looking at the protest letter, it was sent. Mr. Johnson is the president. He was identified as one of the designated representative. I do not know, and so it was sent to him. So therefore, I'll make a motion. I'm making a motion to the board that we deny the objection because it was sent to one of the designated representative of the organization. Is there a second?
Ms. Crockett seconds.
Ms. Crockett, a second. The motion will now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
Grandis. I'm sorry, Mr. Grandis is not participating. There's just 4 of us here today. And Mr. Anderson. The matter passes 4-0-0. And just to alert the public, as long as there are 3 board members participating, that constitutes a quorum for all matters. As long as 3 board members are present, that's a quorum. We have four board members who will participate fully in this protest here today. All right. Are there any other preliminary matters? And I guess I'm trying to find out from just preliminarily looking at the.
Mr. Chairman?
Yes, Mr. Stockline. Go ahead, sir.
I'm very sorry to interrupt you, but I don't know whether you would consider this a preliminary matter or not. But
what's that, sir?
Well, in our PIF, which we submitted and that you just referenced, we stated our intent not to call any witnesses, but instead are seeking for the board to take administrative or judicial notice of the records in 2 other cases from the past 12 months, which are highly relevant. So I can speak to that later when we have the opportunity to present case in chief, but I just wanted to raise it now in case you consider that a preliminary matter.
That's fine, sir. As you are correct, all the board's records, they're part of the case in chief. My assumption is that the investigative history is in their investigative history. Hold on a minute.
One of the cases, Mr. Chairman, is Signature Lounge, which is another club owned by
I'm sorry,
by
signature.
the applicant here. Signature Lounge. It is directly tied to. It's owned by the common ownership, right? So the owner before you today, the applicant, also owns Signature Lounge. So I suspect that is certainly part of the investigative report. However, because I didn't receive the investigative report either, I can't tell you exactly what appears in it, but I suspect that the other case that we're seeking the board to take judicial notice of may not have been included, and that is the case that you may all remember we spent 10 hours discussing not very long ago, Empire Lounge.
Okay, these cases are distinguishable. So I mean, if you want to, if when he testifies, if you want to establish on the record that he's the owner, and you're welcome to cross-examine and asking questions. Of course, counsel will make an objection whether or not his ownership of another establishment, if that is correct, wasn't that's relevant here, but those are questions that you can raise at that time if you want to question him on that, and then the board would make a determination at that time where we are. I was just looking through the investigative report to see if Mr. Miller had listed their investigative history in the report, so that's what I was looking at while we were speaking. But that's all. Those are questions that you can ask as we move forward in this case. Okay. All right. Well, all right. So the way the process, and based on the fact that I was told that does the ANC plan to call in witnesses? So basically, are there any witnesses are the protestants calling in witnesses today? I know you said you're not calling Mr. Stockline, but as far as the ANC is concerned, there's no witnesses?
The ANC will not be calling witnesses, but I would like to just make a statement.
Or that's fine. I will allow that to happen. All right. So this hopefully will be relatively brief.
Mr. Anderson, on that point, there will be an objection. We can address it at the time.
An objection to what, sir?
Objection to the ANC making a statement, I suppose some type of non-witness statement. We can address it now, or we can address it at the time. Just to thumbnail my position, the ANC joined in the WNA's PIF, where both the ANC and the WNA affirmatively represented that they would not be calling any witnesses. So either testimony or a non-testimonial statement would not be appropriate in this case. And
but
again,
as you're aware, Mr. Bianco, that the statute, whenever there are more than one protestant, the statute states that the board can force the party to designate a representative to represent both protestants. You are aware of that. And you're also, I'm sorry, go ahead, sir.
No, I'm sorry, Mr. Anderson. I didn't mean to step on your toes. You could certainly finish your thought.
And I'm saying that you're also aware that in all of the cases that I've had, I have, since the ANC was granted stand-in to protest this matter, that I've always allowed the ANC to make an opening or closing statement if they so desire in all of my protest hearings. So whether or not they are whether or not they've deferred to another entity to move forward with the case in chief, I've always allowed the ANC in all my protest hearings in these type of matters. I've always allowed the ANC to make a statement if they so desire.
No, I understand that. I'm very familiar with the board's practice, and I appreciate you certainly putting that on the record. So I would say a couple of things. One, this wasn't the ANC deferring to WNA. This was the ANC and WNA jointly filing I'm certainly aware of the board.
Hold on, Mr. Bianco. We lost you for a minute. You said, right, so you can start back over, sir.
Sure. So what I'm certainly aware of the board's practice generally. I would say this case, the PIF filed was not an ANC deferring to the WNA. This was a jointly filed PIF by both the WNA and the ANC. And I'm very familiar with the practice of the board allowing a protestant to testify where they either have identified no witnesses on their PIF or where they have not filed a PIF. However, this is different because this isn't a case of omission. This is a case of affirmative representation that they are not putting on a case in chief. Now, as to the ANC making an opening or closing argument, I have no objection to that whatsoever. What my issue would be the ANC putting in evidence when they have affirmatively represented.
Mr. Bianco, I don't mean to interrupt you, but I think we can short circuit this because I think maybe there was a misunderstanding. All Commissioner Bennett intends to do is make an opening statement on behalf of the ANC. That's my understanding.
Nope, I have no problem with that. As long as it's not evidence, I'm good.
And I believe that was my understanding, Mr. Bianco. Okay,
That was my misunderstanding. I didn't mean to waste everyone's time.
All right. Oh, well, it's never wasted time. I was hoping that maybe with all this conversation that the parties would agree to settle the matter. Then, so it would have been a fruitful discussion. Okay. Yeah. All right. The way the process works then this afternoon is that the board will call its witness. So we'll have the investigator. He will go through his report. The board will then question the investigator on the contents of his report. Once the board questions the investigator on the contents of his report, then you, Mr. Bianco, will have an opportunity to cross-examine the investigator. Once you have cross-examined the investigator, then the protestant will cross-examine the investigator, and then once that's done, you'll call your witness, present your case, and if the protestants have a case and witnesses to present, then they will do so. But prior to us starting the case, each side will have an opportunity to make an opening statement, and so therefore, if you so choose, each side will be given 5 minutes to make an opening statement. And your opening statement, let us know why we're here and what is the request that's been made by each side. So, Mr. Bianco.
Very briefly, Mr. Chair, today we're here to talk about a substantial change for VIP Lounge, which is located at 1926 9th Street. It was relatively recently acquired by my client, Mr. Daniel, in October of 2021. Between October of 2021 and March of 2022, the establishment was not operating as Mr. Daniel was making preparations for opening and doing some build out of the premises appropriate to his use. He opened in March of 2022. The license that is presently in place and was in place at the time that he opened is a CR license. It has endorsements for live entertainment, dancing, and a cover charge. Presently, the hours of operation the hours of sales and service, and the hours of entertainment go until 1:30 a.m. during the week and 2:30 a.m. on the weekends. The establishment presently has an occupancy of 78 people. What we're seeking is first to convert the license from a CR license to a CT license. In conjunction with that, we are seeking to extend the hours of operation, service, and entertainment by 30 minutes. The third thing we are seeking is to increase the occupancy from 78 people to 185 people, which based on the estimates of my client's permit expediter is where we will land on the certificate of occupancy once that is processed, but we understand it could end up being something less than that. The evidence is going to show that this establishment operating as a CT with 185 persons in occupancy is comparable to many of the 55 other establishments within the relevant area of consideration. And it will not adversely impact the peace, order, quiet, and other issues raised for protest in what appeared to be a boilerplate protest letter. Protestants, for their part, are not putting on a case. They're resting their issues on things that occurred long ago in other establishments, either having nothing to do with this establishment or are inappropriate for the judicial notice that they are seeking. I'm not going to preview the argument here, but I'm certain at the time it is raised, the debate will be spirited, and confident that the board will make the decision according to the law. And at the end of the day, we'll find that the applicant has met its burden and allow this conversion and substantial change to go forward. Thank you.
Thank you, Mr. Bianco. Mr. Bale, do you wish to make an opening statement?
Yes, I do. Okay. Just want to thank the members of the board for being here and listening to us. So as an ANC commissioner, as the ANC Advisory Neighborhood Commission, we are elected to and required to be responsive to neighbors. And we have heard dozens of neighbors contact us about this license, specifically this substantial change to a CT and increasing the capacity and those other items that Mr. Bianco just mentioned. We have to be responsive to neighbors, and I am asking the board members today to also be responsive to those neighbors in enforcing the law and to deny the substantial change application or impose restrictions to preserve the peace, order, and quiet in the community. I would like to also emphasize that we've heard from folks that are beyond the borders of the Westminster Neighborhood Association that's here today. We've heard from neighbors on 9th Street, on U Street, and the surrounding communities. I want to call attention to a fact that Mr. Bianco just mentioned, that he said 55 establishments in the relevant area. The block in which VIP Lounge is located is arguably the densest concentration of ABRA licensed establishments in the entire city. I think you guys can look at your own data to confirm that. This area is not conducive to a certain critical mass of bars, and neighbors in the area feel like it's reached a critical tipping point. There's extremely narrow sidewalks. There's nowhere for people to line up safely outside of all of these establishments. There's issues with trash. There's not an easy way to manage trash in the area. These are just an example of a few of the items that we've heard from neighbors in concern. These neighbors don't have attorneys. They don't have permit expediters. They just have the ANC to voice their concerns. You may all be familiar that there's a zoning code that caps the number of ABRA licensed establishments, restaurants, and bars on many blocks in this area to 50% of the first floor frontage. This block is not covered by those zoning regulations. So what we've seen is over time, more and more and more ABRA licensed establishments be permitted here, and increased capacities, and a worrying trend of CRs becoming CTs, becoming nightclubs. We at the ANC and the neighbors feel there should be a healthy mix of uses. What we've seen is longtime restaurants be squeezed out and be replaced with lounges, nightclubs, which is exactly what's happening in this instance. We are replacing a small restaurant CR license with a CT that is a lounge / nightclub, and essentially doubling the capacity. And so I do want all the members of this board to consider how that would impact the already highly concentrated area. And so I would argue that you have to view this expansion in light of everything that's already there. And as Mr. Bianco said, there are a large concentration of establishments right here. And I'll just conclude by saying, the way that, as you're all familiar, ABRA violations accrue to the licensee, and the license is attached to an address. So someone can run an establishment on one side of the city and then open another establishment in another neighborhood, and those past violations aren't necessarily tied to that operator, they're tied to that license. So what we've run into here in this area is that neighbors have made noise complaints, neighbors have had issues, and they feel as though it's the price of doing business, and some of these establishments have not, are able to expand and how owners are able to have more locations, and past conduct is not taken into account. Mr. Bianco seems to think that it's irrelevant, but I think that the neighbors who I represent, who are kept up at night by noise, who complain about, who face issues walking on the sidewalk, issues with trash, would think differently. So again, to sum up, we are asking that the board deny the substantial change application that is changing from a restaurant to a tavern and drastically increasing capacity, adding endorsements, and we ask that you deny that or place restrictions. And I'm sure you'll hear more from Mr. Steckland, but that's what I have to say.
Yeah. Mr. Steckland, do you wish to make an opening statement?
I do.
Go ahead, sir.
In addition to everything that you heard from Commissioner Benna, just like to add a few key points and then also provide a quick clarification. You have heard in many instances over the past year in various proceedings tied to establishments on the block in question from residents citing all the different disturbances and concerns related to violent crime, to noise, to trash, to safety, to traffic, all the things that are enumerated in the statute as being bases for approving or denying, requests. That there are persistent problems on this block where the applicant is proposing a substantial change. You've heard from MPD officers that they don't believe even the slightest additional increase in capacity of establishments located on this block.
Mr. Stockline, hold on 1 minute. I know you're outside and I know you live in a city, but I'm hearing the interference from the city. I guess the truck is backing up. So is there any way you can be indoors, sir? Because it's while you have your microphone unmuted, we're hearing, at least I'm hearing all the neighborhood noise.
Sure, I apologize, Mr. Chair. I'll try to go inside right now. Pardon me, everybody. Is this better, Mr. Chairman?
Yes, thank you. We're no longer, at least I'm not hearing the noise from the neighborhood. And I know I saw at one moment when you had your camera on, so I knew you were outside. But all right, go ahead, sir.
Yep, I apologize. So you've heard in many instances, or you've heard from the MPD that they don't believe that any increase in and overall capacity of nightclubs or taverns or attendees at existing nightclubs or taverns is in the best interest of public safety and welfare, and so that's certainly all the more the case here, where the applicant is not only proposing to transition a restaurant into a CT license, which effectively will operate as a nightclub, but particularly so when they're proposing to more than double the capacity. So this is a really significant proposal, which will have significant adverse impacts on the community. And it's being proposed by, as you'll hear shortly, an applicant who has a history of not being able to effectively manage, based on your own judgment, his existing establishments. So the idea that he should be put in a position to, to replicate the same harms in yet another establishment seems unconscionable. And the last thing I'll say, this is the clarification, is that, while I realize that the board does not have primary jurisdiction over zoning matters, you're no doubt aware that that there is a restriction on the number of liquor licenses that can be issued within a given area by this board based on the zoning code. And Commissioner Benna, this gets into the real weeds of the zoning code, so I'll try to steer clear of that as best I can. But Commissioner Benna may not have been aware that, in fact, the west side of the block in question, on which VIP Lounge is located, which is Square 361, is included in the arts overlay and in the codified table, which is where there has been some confusion, and is therefore explicitly subject to 50% cap. And the administrators made clear that it's in fact already over that cap. So for that reason, I wanted to just make that small point of clarification and reiterate that we have way too much on this block already. So there's just no way that the board should approve this in what is the highest density area of liquor licenses already in the city. Thank you.
All right, thank you. Mr. Miller. All right, so I will ask everyone to mute their phone, please. If you're not speaking, please mute your line. All right, so Mr. Miller, can you raise your right hand, please? You swear or affirm to tell the truth and nothing but the truth?
Yes, sir.
Can you state your name for the record, please?
It's Jovan Miller, Jovan Miler.
And where are you currently employed?
I'm employed at the Alcoholic Beverage Regulation Administration.
And how long have you been employed by the agency?
3.5 years, sir.
What is your role at the agency?
I am an investigator.
Specifically, what are your duties and responsibilities?
I conduct investigations and inspections of ABC licensed establishments throughout the District of Columbia.
Did I swear you in?
Yes, sir.
Okay, I apologize. All right. All right. Are you familiar with this establishment? Are you
Yes,
familiar
sir.
with this protest, the issues that are being protested today in this case?
Yes, sir.
And how is it that you became familiar with the issues that are being protested in this case today?
I was assigned this protest through my supervisor, shares.
Now, what are do you know who the protestants are?
I do, but I do not know how to pronounce Mr. The owner's name correctly. I don't want to mess up his name.
All right, but so the protestants are what you're saying are the
ANC in the Westminster Neighborhood Association. Yes, sir.
All right. Now, what is it? Do you know what's been protested? What's this case is about?
Oh, yes, sir. So in particular, Did you want me to re-enter? Well,
No, I'm just asking you, do you generally, what has been, what is, what type of action has been requested today? It's a substantial change, and so tell us what is a substantial change from what to what? You're right. Yeah.
oh, yes, sir. So this was a substantial change from CR to a CT, a change in occupancy, also a change in hours of operations for sales and consumption and live entertainment.
Now, you said it's a change from a CR to a CT. What's a CR?
So CR is a restaurant, you can sell alcohol, beers, and wine. And then a CT is a tavern who just sells mostly, could sell the same thing, but not regulated to do food sales as much.
All right. Did you have an opportunity to speak to any of the protestants in this case?
No, sir. Well, I didn't get an opportunity to discuss the protest. The day of my authoring of my report to my supervisor, I did get an opportunity through email to speak to Mr. Stockland and Mr. Orlasky, but I was unable to get any information in regards to the protest.
All right, so you're saying that you got an email. What email did you receive?
So I sent out a last email to both the ANC and Westminster Neighborhood Association to get information more about the protest, and I didn't receive a response until the day of I'm authoring my report.
So what was the response you received?
Make sure I'm correct. The Westminster Neighborhood Association responded in summary that they had spoken with the ANC, and that the ANC had more information to provide than the Westminster Neighborhood Association, and they had nothing further to add. And then for the ANC, we were unable to communicate telephonically due to time restraints the last day. But before that, I have no responses from the ANC.
So how many times did you, when and how many total times did you attempt to communicate with the ANC and the Civic Association?
I believe 3 or 4 times maybe. I know 3 minimum. I did reach out to I want to say it was the ANC. Trying to remember who provided their contact information. I want to say it might have been Westminster Association. Actually, it was the ANC, excuse me. It was the ANC. I tried to telephonically call them and the number was not working. So I would say 4 for them and 3 times through email for Westminster. And then I also direct email through Teams, Mr. Olasky, and no response.
Can you tell us about the characteristics of this neighborhood, please?
Yes, sir. You're speaking directly of the building, correct, sir?
All right. Let me ask you, did there come a time that you draft a case report regarding this case?
Yes, sir.
And can you share this case report with us, please?
Yes, sir.
Can you identify the document that we're looking at the screen, sir?
This is my protest report I had written for the.
When was this?
For the,
when was this report written?
This report was written September 23rd, I believe. Completed September 23rd, 2022. Excuse me. It was September 19th, 2022.
So we're going to go through your report now. So can you tell us about the correct characteristics of the neighborhood?
Yes, sir. The establishment is on it's located at 1926 9th Street. Very busy street during the nights, especially during the weekends. It has in the vicinity 55 establishments, ABC licensed establishments in the area. During the day, it's pretty quiet, mellow. The building itself is a brown, black and yellowish building, I want to say. And as far as like they have like 1 metro stop in the area. They have 6 metro bus stops in the area. And it has limited parking on 9th Street where the location of the establishment is. And it has little parking along the side streets.
So what type of endorsements, and so you're saying that currently this establishment is a CR, which it operates as a restaurant. What type of endorsements does it currently have?
It just has just give me 1 second, Chairperson. I want to make sure I go to the license. Oh, there you go.
Why don't you go to page?
It has a cover charge, dancing, entertainment, and holiday extension, sir.
And what are the current hours of operation of this license?
The hours of operation Sunday through Thursday is 11 a.m. to 1:30 a.m. On Friday and Saturday, it's 11 a.m. to 2:30 a.m.
Now, have you had an opportunity to observe this establishment as a result of your protest investigation?
Yes, sir.
And when did you observe this establishment?
I personally have visited the establishment 3 out of the 5 times that it was monitored. During the times that I have monitored, there has not been much activity. The establishment was not very busy with patrons. It's never been to a point where I visited the establishment and it had over 30 patrons inside. I did see trash, but it was a collective of other establishments, so I could not say that it was the establishment's trash, because 9th Street usually have patrons who litter often. And as far as violence or anything outside of the norm of 9th Street, there was none I could particularly say that it was for a VIP lounge.
So you're saying you said you personally observed the establishment on 3 occasions. What were the 3 occasions that you personally observed the establishment?
I personally observed on
I think if you go through your report, you can. I'm going through your report, and if you go through your report, if you follow your report, then you can answer the questions if you follow the report, sir.
Yes, sir. Here we are. All right, I visited the establishment on Thursday, September 1st, September 10th, 2022, and Friday, September 16th.
So can you tell us what is it that you observe on what time did you observe the establishment on September 1st?
From 7:50 p.m. to 8:20 p.m.
Can you tell us what, if anything, did you observe?
The establishment was not busy. I actually visited inside of the establishment. It had 1 patron inside, and not much activity going on.
And you also tell us about your observation on September 10th. And what time was that?
On September 10th at 8:49 p.m., excuse me, to 9:30 p.m. Also, I visited the establishment It was not very busy at the moment that of the time that it occurred. I didn't see much patrons visiting inside the establishment. The establishment has one security at the door. It didn't really have any staff inside except for 2 people. So, and then on September 16th, that Friday, I visited the establishment from 11:56 p.m. to 1 a.m. I stayed a little longer just to observe the establishment, and it has also few patrons inside and not much activity going on.
You went on a Friday night, you left at 1 o'clock and there was not much activity going on in this establishment?
Yes, sir. I believe it has another establishment right beside it. Had a little bit more patrons inside, which is Secret Lounge, and then MK Lounge is right beside that. That were visiting more of those establishments. Yeah.
Now, no, this establishment doesn't have an investigative history?
No, sir.
Now, I see that there are exhibits attached to your report. Can you please go through the exhibits that are attached to your report, please?
Yes, sir. The first exhibit is the Westminster Neighborhood Association's protest letter submitted to ABRA. That's exhibit 1. Please let me know if I'm going too fast. Exhibit 2 is the ANC's protested letter to the board. Exhibit 3 is the zoning for the establishment. Exhibit 4 is the GIS map for all the establishments in the area.
Approximately how many establishments are, just approximately, I see there's a lot on the list, approximately how many establishments are in this area?
55 establishments, sir. Exhibit 5 is the GIS of the schools that's in the area, which are 0. And then it goes into the front of the establishment. This is VIP lounge front door. This is just the upper part, just to give an overview of the establishments. You can see a few cameras out front. This is when you walk into the establishment on the first floor. This is the window that you kind of can see from, that was kind of covered up with the sign right here with the picture of alcohol. That's the window that you're observing. Also more pictures of the first floor, just giving out the layout. More of the interior on the first floor. To your right, you'll see the window for the kitchen area. And further back is, I believe, a bathroom. Here's more just an overview of the first floor. This is the bar to your right. This is going further into the kitchen. You have a camera, just more kitchenware. Also more of the kitchen. And they have exit back door. More of the kitchen, freezer. Back door. Ice maker. All right, this is when I open the back door. This is their trash area. They have these 2 trash cans. More pictures of the trash area. All right, this is when we went upstairs, took pictures. This is as soon as you walk through the front door, you're able to go up the stairs or to the left to the first floor. This is as soon as you enter the establishment to get to the top. This is the picture to the left to show the upstairs area. More of the first area as soon as you look by the window. When you turn more to your right, there's a media bar as soon as you walk up the stairs. This is the DJ booth area that's right beside the bar. And then it opens up to more seating area with a bathroom through that door where it says VIP. Some more seating area upstairs. Seating areas, same area. This is the back door. The exit right there.
You know,
You
you should close your thing.
This is also the bathroom area.
Oh, you wanted to eat that? Did you go on pork one?
I'm sorry, Mr. Are you not? I'm hearing all that noise in the background, sir.
Give me 1 second, Chairperson. Sorry about that, Mr. Chairperson.
Go ahead, sir.
This is also just another picture of the bathroom. Then we get into the exhibits of the ABC license. This is a picture facing downwards of 9th Street. Pictures of parking along 9th Street on the same block as the establishment. Here's another just picture of parking situation. If you look next to the yellow building to the right of it, that is VIP Lounge. More pictures of parking signs. Also parking. Parking on the opposite side of the street. This exhibit is the settlement agreement for the establishment for a summer garden. Summer garden that's supposed to be on the rooftop. That is not there yet. This is a picture of the 16 cameras that the establishment has. I believe the establishment has 7 cameras on the second floor, 5 cameras on the first floor, 3 cameras in the front, and 1 camera behind the establishment. This right here is a record search from, record search from the Office of Unified Communications for calls for service. Just to note, they have 2 calls for service from March 24th to 2022 to March 27th, 2022, when, excuse me, VIP received their ABC license March 22nd. So the ones that you received from April 4th, 2021 to March 27th, 2022, excuse me, sorry, from January 31st, 2022, I cannot say it was associated with VIP Lounge, but these other 2 weren't associated. It just has the address of the establishment. It didn't specifically state VIP Lounge.
Okay.
And that's all of my exhibits, Chairperson.
All right. So you can close your screen, please. Any questions by the board members? Go ahead, Mr. Short.
Thank you, Mr. Chairman. Good afternoon, Mr. Miller, or Investigator Miller.
Good afternoon, Mr. Short.
So how many years have you been with ARPA as an investigator?
3.5 years, sir.
3.5 years. Now, during your training periods and your initial start with ARPA, did you get any training at all on public safety?
No, sir. Not that I can recall.
Can you bring your screen back up again? I just want you to bring up your screen and go to exhibit number 30.
Yes, sir.
Thank you.
Yes, sir. Oh, sorry, I didn't share it. That would help if I shared it.
Okay,
Yes, you are.
that is the rear exit door. Is that correct?
Yes, sir.
What is that leaning against the wall?
Table, sir.
So how many people are on that first floor according to the C of O now? And what is the occupancy now for the building?
I believe 74, if I'm not mistaken.
How much?
I believe 74, but I can, excuse me, 78, sorry.
78. And they want to increase that to how much?
One 84, 80 something, excuse me. I want to be mistaken.
It's in your report somewhere, I know, and it's also in their request, so eloquently spoken by the attorney, that they want to take it to
185.
Excuse me?
185.
185.
Yes, sir.
Now, during your inspection, and when you took that picture of exhibit number 30, go back to exhibit number 30 again, please.
Yes, sir. Yes, sir.
That's great. That's great right there. Now, from the second floor, how many exits are there from the second floor?
There's one exit on the second floor.
And where does it lead to?
To the back alley.
So right beside where this door is, going from the first floor.
So there's a exit. It's be considered 2 exits on the bottom, the front door, and a back door on the first floor, and then 1 exit at the top.
Just for the rear, I'm speaking of the rear now. How many exits are from that building on the rear?
2.
Now, we see the exhibit that you've shown here with the table beside the door, which is a fire code violation, which since you haven't had any public safety training, you wouldn't know anything about that. But the fire marshal would there, that would be a very bad violation. But let's go a little further with that. Now, if you the pictures that you've shown say so much about your investigation of this. I was ask you this: if 185 people had to exit And there's a couple other exits. There's one that you showed where the trash cans were leading from that door. Can you go back to that one? In the rear?
Sir. Mm.
Okay. Now stop right there. Now, how far are those trash cans from that rear door where you just showed from the first floor? How far are those trash cans from it?
Up 6 or 7 feet.
So, and you have to go past another gate to get to the alley from that. Is that correct?
I don't believe it has two gates, or a door and a
No,
gate.
I'm confusing you. Please forgive me. I'm sorry if I've done that. Now, if I'm standing right there where you took that picture, and I just came out with 185 people behind me, how would I get to a public way?
There's an alley to the right and the left, I believe, if I can recall, that they can exit back to the street area from
But
behind the establishments.
they'd have to go past these trash cans first, correct?
Yes, sir.
Thank you very much for that. Now, again, you said there, as far as you know, there's no history for the VIP club. Why would you say that? If it's how long has the VIP club been there?
Since March of 2022.
What was there before March of 2022?
I do not recall, sir.
Would you believe me if I told you there was an existing VIP club there?
I will believe you.
Okay. And would you believe that their history would say that they were in violation of mayor's orders and other types of violation for Arbor that didn't come to testimony today? And I don't know why it wouldn't come to testimony today, but this is your report, and I'm not going to question how you did your report. But what I will question is, if you don't know the history before March of 2022, how can you give an accurate report on this business?
I'm gonna, Mr. Chair, I'm gonna object. This is inappropriate in several material ways. The first of which, it assumes facts that are definitely not in evidence. The board member is giving testimony about what previously existed there. And oh, by the way, it's wildly inaccurate. So if we could stick to the investigator's actual testimony as opposed to inventing facts, I think it will get us through this much quicker.
Mr. Short, there's no investigative history that is with this establishment. And so I'm not quite sure if we can, since there's no facts and evidence regarding a previous investigative history, unless the information is provided by the investigator is correct. It's incorrect. I'm gonna go with that there is no investigative history for this establishment because it's mine. Right. So we need to stick with the investigative history that is in the record. If there's some of the record that states that there's a different investigative history, if that's brought about, then you can cross-examine that witness on that investigative history. Okay.
I do thank you for that clarification, Mr. Chair. And I still would just like to basically go to the current application. As far as you know, Investigator Miller, the current number of persons allowed in the building is 85. Is that correct?
Current number is 74, sir.
Oh, forgive me, 74. And they're asking to go to what number?
185.
So you've been with the agency for 3 years. Is that correct?
3.5, sir. Yes, sir.
3.5 years. Forgive me. I didn't cut off your 6 months. Now, as many as establishments have you been in, especially in this area and on 9th Street, how many of them have an occupancy of over 180 people?
I do not recall, sir.
You don't know of any others that have 180 people?
Not off the top of my head, sir.
Okay, that's a fair answer. Now, again, I am concerned about the welfare of the community, and your testimony and your report mean a lot to me as a board member. And again, I've heard your testimony is you've had no training on public safety. Is that correct?
Yes, sir.
All right. Now, let's do this. You've told me from the building itself, there are how many exits? I wanted this on the record. How many total exits from that building for this applicant?
3, sir.
3 for the whole building.
Yes, sir.
1 from the first floor and 2 from the first floor and 1 from the second floor, correct?
Yes, sir.
And the 2 in the rear have to accommodate all the people from upstairs and the people from downstairs. Is that correct?
Yes, sir.
Okay. Now, I'd also like to ask you, you showed some pictures of the parking and the traffic on 9th Street. Can you bring those up to me on your exhibit, please?
Yes, sir.
Okay, that's fair.
Is there a particular picture that you would like to see?
How many times have you been on 9th Street at 2 a.m. in the morning in the 1900 block of 9th Street?
Often, sir.
What is the traffic like there at 2 a.m. on any night of the week, especially the weekends? How are the traffic conditions and how are the pedestrian conditions, especially on the sidewalks?
As far as the road goes, Mr. Short, due to nightlife enforcement, 9th Street is mostly blocked off from patrons entering onto the 1900 block of 9th Street. As far as patrons go,
let me stop you there. Why was that necessary for? Was that for public safety?
I would have to defer to Mayor Bowser, sir.
Okay, that's fair. Now at 2 or 3 o'clock in the morning on 9th Street, weekends or whenever, and it's so crowded the MPD has to impede the traffic. Do you think allowing more people there will help or not help the situation of public safety on 9th Street, the 1900 block of 9th Street Northwest?
Honestly, I could not tell you, Chairperson.
Okay, that's fair. Now, let me ask you this question. The applicant, Mr. Danelli, or Mr. Danell, forgive me if I'm pronouncing it wrong. How familiar are you with him, the applicant for this application?
I met Mr. Dinaji, I'm sorry if I pronounced it wrong, a few times due to another protest that occurred, and also visits to the establishment for regulatory inspections.
Can you give the name of that location?
I visited VIP Lounge, and I also visited Secret Lounge for in a few years back for a protest report I had authored.
So you're very familiar with this licensee. Would that be fair? Would that be a fair question for you to answer?
Yes, sir.
Are you fairly familiar with him?
Fairly, I would say fairly.
Are you fairly familiar with his business practices?
As far as the inspections, yes, sir.
Have you ever cited him, or do you know of any other investigator who has cited him for arbor violations?
I don't recall given any ABRA violations personally that I can recall off the top of my head. As far as other investigators, I could not recall as well.
Okay, that's
As
fair.
of recent years, no, I don't recall giving any violations.
You've done well, sir, and I hope that you have many more years with ABRA and you continue to do what you're doing. I would suggest if you can't get training from ABRA that you do some reading on public safety, because your job and people drinking alcohol in establishments such as 9th Street, the 1900 block, could help save lives. Do you agree with that statement?
Yes, sir.
Do you agree with that statement? Excuse me?
Yes, sir.
Okay. Thank you. That's all I have, Mr. Chair. And thank you again for your report, Investigator Miller.
Thank you.
Thank you.
Thank you, Mr. Short. Close your screen, please. Any questions by any other board members? Mr. Bianco.
Yes, Mr. Chair, thank you. Investigator Miller, thank you very much for your testimony. I have a few questions for you. I'd like to start with inquiring on the questions that Mr. Short asked you. At the time you visited the establishment and took the photographs, was that during the day or at night?
I was during the day.
And was the establishment open for business?
No, sir.
Okay. And directing your attention, you don't have to put it up on your screen. I think we all remember it. Directing your attention to Exhibit 30, which was the photograph with the table in proximity to the back door. Are you able to say whether or not that table stays there during operating hours?
No, sir.
Okay. And Mr. Short asked you to opine on the ability of 185 patrons to leave that establishment in the event of an emergency. Do you recall that line of questioning?
I do.
And is that something that is within the purview of ABRA investigators?
No, sir.
Okay. The appropriate occupancy load is something that is determined by DCRA, is it not?
Yes, sir.
And the appropriate pathways for a fire exit is something that is determined by the fire marshal, is it not?
Yes, sir.
And do you know whether or not those two inspections are prerequisites to getting a certificate of occupancy?
They are.
Okay. Now, I'd like to cover a couple of other things. So attached to your report is an exhibit that is a settlement agreement. Are you familiar with that?
I am.
It's actually Exhibit 40. It discusses a summer garden roof deck. Is there a summer garden roof deck at this establishment?
No, sir.
Okay. And that's not part of the license application, is it?
I do not recall.
Okay. Now, both the ANC and the WNA's protests are for peace, order, quiet, vehicular and pedestrian traffic and safety, correct?
Correct.
I'm sorry. And I'm sorry, I misspoke. I'm gonna bring up the letter so I can say what they are with specificity. So please strike that. And if you'll bear with me for just a second while I bring up the letters. Okay, so the ANC letter, which is marked as Exhibit 2 to your report, protests based on the effect of real property values, the effect on peace, order, and quiet, including the noise and litter provisions, and the effect upon residential parking needs, and vehicular and pedestrian safety. That's what the ANC's letter of protest cites, correct?
I believe, I want to say it says the licensee records of compliance with DC official code as well.
Okay. Are you looking at the ANC letter or the WNA letter?
Give me one more to make sure I'm correct. Oh, excuse me, that was the ANC's. Nope,
Okay.
it was the ANC and Westminster neighborhood on the second page of Exhibit 1. It also said the licensee record of compliance with DC official code or regulations promulgated under the DC official code. Not limited to the terms and establishment existing in the settlement agreement.
Okay, so that's Exhibit 1, which is the WNA letter, correct?
Correct.
All right, so let's talk about that one first. Did the WNA ever explain to you what specifically they contend would adversely impact peace, order, and quiet?
No, sir.
Did they ever specifically explain to you what they believe would impact real property values?
No, sir.
Okay. Did they ever explain to you what impact the establishment might have on residential parking needs and vehicular pedestrian safety and traffic?
No, sir.
Okay. And they also cite the licensee's record of compliance with DC official code and the regulations. You see where it says that?
Yes, sir.
Okay, and if I understand your report correctly, under the investigative history portion, there are no violations of DC code or regulations. Is that correct?
Yes, sir.
And during the times you and other ABRA investigators visited there for the purpose of this report, no violations were observed. Is that correct?
Yes, sir.
Okay, and then finally, the WNA says that they have violated the terms of their existing settlement agreement. Do you know what the WNA is talking about with respect to that?
No, sir.
Okay. And did either the WNA or the ANC cite an overconcentration of establishments in the relevant area as grounds for a protest?
I'm not. Can you restate that question so I can understand a little bit better?
Sure. So I'm looking at exhibits 1 and 2, which are the ANC's protest letter and the WNA's protest letter.
So you're asking, did they list that as like one of the issues or concerns? As okay, no.
Okay. And I think, okay, so the hours of operation they presently have, which is closing at 1:30 a.m. during the week and 2:30 a.m. on the weekends, do you have a sense as to whether that is earlier or later than most of the establishments on 9th Street?
Most establishments on 9th Street are able to stay open to 3 a.m.
Thank you very much, investigator. I don't have any further questions for you.
Yes, sir. Thank
you. Mr. Stockline, any questions?
Yes, Mr. Chairman. Can everybody hear me all right? Hello? Can you hear me all right?
Your voice is not clear, sir.
Okay. Just one moment, please. I'll try to change audio.
That's better.
Is it correct? Yeah. In your report, you indicated 5 instances in which you visited the establishment. Is that correct? 5 separate instances?
Yes, sir.
And you observed a total of, and how many individuals did you observe in total over that period of time? Patronizing the establishment.
In each instance that I visited the establishment, inside of the establishment, first time I believe it's one or two people. One other instance is about maybe 30 people, and other instance no more than like 20 or 30 people. It was not very it wasn't very busy when I visited the establishment.
So you said on more than one occasion you observed 20 to 30 patrons? Is that correct?
I believe so. But on at least one occasion, I believe there it was only about 30 patrons. Other 2 times, it was not a lot of patrons inside of the establishment.
And did you inquire as to whether those patrons were employed by the applicant?
If they were employed?
Yes. And were they employees of the applicant? Are you aware of whether they were employees in any capacity of the applicant?
From my observation, they were just patrons who visited the establishment.
Are you aware that the applicant regularly utilizes the establishment
Made a comment.
in order to provide, food and an area to relax for his employees at the next door property, Secret Lounge?
I'm sorry, I only heard bits and pieces of what you stated.
Are you aware that the applicant regularly utilizes the space in question today merely to provide food to those individuals that he employs next door at Secret Lounge?
I am unaware of that.
And so, can you confirm that the individuals you observed were in fact independent paying customers rather than employees or agents of the applicant?
I can.
You can?
I can. You're asking if I can confirm that they were
employees. Independent paying customers versus individuals that may or may not have been employed by the applicant.
The establishment, when I visited the establishment, the staff had on a certain attire that separated them from the patrons. If they were staff of the establishment and they were dressed in regular clothing, and I would assume that they are patrons.
Okay. Did you identify or observe a website for the current establishment?
You said a website?
Yeah, you have a website.
I'm unsure.
You're unsure because you didn't observe one or because you didn't look?
You said a website?
Yes, a website.
No, I didn't look into their website. I did not look.
Okay. Did you review or observe any kind of a menu offered by the establishment for the food that it serves?
I did.
Okay. And did that menu appear anywhere in your investigative report?
It did not.
Okay. Are you aware of the statutorily enumerated criteria against which ABRA is obligated to assess the appropriateness of applications, whether it be for a substantial change or renewal, et cetera? Are you aware of the criteria?
I would say that the criteria would have to go more to the administrative team than the enforcement team.
And so I'm just going to make sure I understand your answer. Are you suggesting that the administrative team is responsible for considering the criteria, or?
I'm saying that the administrative and licensing team has the criteria for a person to become an ABC licensed establishment.
Okay. And so then in conducting your investigation, how is it that you determine what to collect evidence on, what to observe? How do you determine the proper scope for your investigation if it's not based on those criteria?
What criteria are you speaking of in particular? So maybe I can help us out.
Early enumerated criteria that were cited in, well, first of all, that are cited in statute in your DC code, but also that were recited in at least WNA's protest letter.
So for enforcement, we have a regulations, official DC official codes that we use to do enforcement. So any DC official codes on violations, that's what we use to cite citations or cite or have hearings or violation protests or anything like that. We use that official code. So the criteria, if you're speaking of criteria as far as them becoming an establishment, that would go more towards licensing and administration.
Maybe we're using different words to describe the same thing, so I'll try to move on. Are you aware that one of the areas of consideration for granting applicants' requests today is, as enumerated under the regulations and statute, is the effect of the establishment on the residential parking needs and vehicular and pedestrian safety?
What was the beginning part? I'm sorry. I'm having a hard time hearing you.
Quoting directly from statute now. The effect of the establishment upon the residential parking needs and vehicular and pedestrian safety.
Are you asking me about it? I didn't hear that. I'm sorry. I'm not hearing the beginning part.
I'm just trying to establish whether or not you're aware that that's one of the fundamental bases upon which you and the board are required to assess whether or not it's appropriate to grant an applicant's requested relief.
I would say that was more for the board to assess. My job is just to gather the information.
Right, and how do you know what information to gather if you don't know what you're supposed to be gathering information to demonstrate?
I'm confused by the question. Where are we getting that? I don't have the information.
How is it that you determine what to put in your report or what not to put in your report if you are not aware of the basic requirements that you are supposed to be assessing for purposes of investigating appropriateness of a request?
I'm going to object. It's asked and answered several times. It also mischaracterizes testimony, which I think was very clear that he gathers facts and puts them in the report. There's no opinions in there.
I'm not asking for opinions. I'm trying to figure out what I had hoped was a relatively straightforward question, which is when the investigator gathers evidence, how is it that the investigator determines what evidence to consider, to gather, to collect, right?
If I'm gathering information about residential parking, I'm going to take pictures and assess the environment of where the establishment is, the parking, how long is parking available? Is there limited parking? Is there anywhere that they can catch the metro, buses, or anything like that? That's my job to gather those facts.
That's what I was hoping for. Thank you very much. So, picking up on what you just explained, do you recall testifying just a few minutes ago that the specific street along the 1900 block of 9th, which is the street in question here, has been recently entirely blocked by the mayor's task force. Was that your testimony, Mike?
Correct.
Okay. And you know when that traffic is being blocked?
I can't recall the date.
Would you say just ballpark? Do you have any idea? Not specific dates, but days of the week, right? Do you generally know when that occurs?
Friday and Saturday.
Okay. And from when to when?
Is that from when to where?
From when? From what time to what time? Approximately.
I believe to 10 p.m. to 4 a.m.
Okay. So for a period of 6 hours on the weekend nights, is it accurate to say that the mayor's task force has entirely blocked through traffic?
I couldn't say.
I'm confused. So I think we were just talking about your observation that the task force prevents traffic from entering the 1900 block of 9th Street during the days of the week and hours that you specified. And so I'm just trying to confirm, based on that observation, whether it's accurate to say that, that no cars are permitted to drive through the 1900 block of 9th Street. Are you
On occasions they allow one side to flow through. On occasions they block it off. It all depends on what they deem necessary for that day.
Okay. In the least restrictive context that you just described, at least 50% of the traffic is not allowed to pass, and in the most restrictive context, 100% of the traffic is diverted to other blocks. Is that correct?
Correct.
Okay. Does that strike you as a significant impact on traffic in the area?
I could not say.
If between 50% and 100% of traffic is blocked and diverted, you can't say whether you view that as a substantial impact on traffic patterns?
Objection asked and answered.
I don't believe that it was.
I believe it's on, if you're familiar with 9th Street, it's always been a busy street.
Mr. Miller, there's an objection pending. Mr. Anderson's going to speak on that.
Yeah, I appreciate the investigator's comment because that's in fact exactly what we're driving at. It usually is a busy street. It's all the more reason why this testimony is so critical.
I'm going to overrule the objection, but I think the bottom line is that the investigator wrote a report, so I don't want to ask him questions out of his expertise, out of what is not necessarily in his report. So let's move on. So we can. All right.
I would ask that I be allowed to, particularly given that, as you heard before, we didn't in fact receive this report beforehand. I'm trying to do my best to ask questions that are directly relevant to the bases upon which we are required to advance our case under statute. And it's my understanding that it is the primary obligation of the investigator to produce facts relevant to any of those of items. So that's what I'm trying to, to make sure that either through the investigator's testimony or the report before you, that we get those facts onto evidence so that you can consider them. That's my only intention.
We will do that, sir. And Mr. Starkline, I want to clarify the record that the PIP was provided to your organization, sir. So I just want the record to reflect that it was sent to your organization. Unfortunately, it was not sent to you, but it was sent to one of the designated representative, one of the named designated representative of your organization, sir. Okay, let's move on.
Regardless, it is important for this board to understand exactly what's going on 9th Street with respect to residential parking, vehicular and pedestrian safety. And that's all I'm trying to put onto the record before you. So, so can you please, going back to what you've observed, I'm just asking you what you've observed. Did I hear you correctly say just a few minutes ago that that this block under consideration is usually a very busy traffic block? Okay.
Correct.
Okay. And is that true for both vehicular and pedestrian traffic?
I could, as of recently, due to, are we speaking before the mayor's,
Sure. Yeah, that would be great. Yeah.
are we speaking before that?
Sure, before and after.
I would say busy, but not as busy as it has been before before the pandemic. So
I didn't mean I apologize. I did not mean the pandemic. I meant
I'm saying it's
after
busy,
the
but it was not.
Yeah.
Before the task force, it was decently busy. Not the norm of 9th Street or U Street, and definitely not after the mayor's night task force.
Okay. Did you observe? No, just one more question on that. So, if the mayor's task force is blocking traffic on the 1900 block at night, can you tell me where it is that patrons would be expected to park who are visiting these establishments?
Well, most patrons either find parking in the parking garages, Uber, or walk to the establishments. And it's not just blocked off for the record, not just blocked off on the 1900 block of 9th Street. It's blocked off from 1900 block of U Street all the way up to the 1400 block of 14th Street. So I just want that for the record. It's not just 9th Street.
Well, yeah, I appreciate that. And that's a recent occurrence. Is that correct?
More recent, yes.
And you, I think you testified earlier that you don't know why that's the case. Is that accurate?
I would have to defer to Mayor Bowser.
I'm just asking whether you know. Am I correct in reciting the testimony that you, when asked earlier why the mayor's task force was implemented or how it was implemented, you indicated that you don't know. Is that accurate?
I would say that there's multiple reasons, but I would have to say you would have to direct that question more to Mayor Bowser.
Okay. Not sure I fully understand. So I think I just heard you say that you are aware of multiple reasons for the mayor's task force. Could you please tell me what?
I said they are.
Sure. Could you please tell me what those reasons are that you're aware of?
I would say that there's been many incidents around the city, and they're just trying to make sure they have public safety. So they're trying to protect the patrons. So that's one reason. And just say another reason would be to mostly it's for just to protect the patrons on the city from incidents that are occurring throughout the whole District of Columbia.
Okay. You just told us that the mayor's task force blocks a sizable portion of the 1900 block of 9th Street and then continuing along U towards 14th, correct?
Correct.
Okay. And are you aware of whether the mayor's task force also blocks, say, the 1800, 1700, 1600 block of 9th Street?
I don't recall.
Okay. What about the 1900, 1800, 1700, 1600 block of 8th Street?
8th Street?
8th Street.
Not that I recall. No.
Okay. What about the 19, 18, 17, 16? You get where I'm going with this block of 7th Street. Do they block that?
Not that I recall.
And what about 6th Street?
Not that I recall.
How about 15th, 16th, TES?
I'm gonna object. Are we gonna go through every street in the District of Columbia here?
Yeah,
It's
I can-
repetitive.
I can make that
and
my
I'm-
last. I can
Mr.
make that my
Steckline,
last
I'm
summary.
articulating an objection. Please don't talk over me. I'm gonna object as this is repetitive and unnecessary. The investigator has answered the questions put to him, and this line of questioning should be put to an end, and we should move on with this case.
Well, Mr. Bianco, the problem here is that the investigator testified the task force, the purpose of the task force, the reason of the task force is to deploy and protect patron safety across the entire city. One would therefore surmise that traffic must be being blocked across the entire city. And what I'm trying to suggest is it's quite the opposite. Traffic is only being blocked in this specific block and section of the city, which is highly relevant to the issues before the commission.
All right.
This is the type of evidence that somebody would put on if they were putting on a case and not trying to elicit through the investigator who testified that he did not know.
All right. I'm going to overrule the objection. Let's move on. I need relevant issues. I need relevant testimony that's going to help the board make a decision.
Well, I hope that the board finds this testimony relevant, but I promise not to continue to review the map of the city because I hope my point has been made clear enough. Mr. Investigator, did you, during your inspection of the establishment, did you observe or measure the space or call it the width of the sidewalk directly outside this establishment?
That's outside of the scope of my job.
Okay. When you are thinking about things like queuing out front of an establishment and patron and pedestrian safety, what do you observe or assess in order to try to inform that question?
I'm sorry, I'm probably not understanding what you're trying to state. Can you just say it again, please?
Okay. I think I've heard you say a few things in the past several minutes that speak to, call it sort of walking traffic, right, rather than vehicular. So that's what I'm trying to focus on here. My question is, thinking about foot traffic, what if anything did you observe specific to this establishment?
As far as patron goes, it's in front of the establishment. It didn't have many patrons in front of the establishment. Most patrons were either, if they were posted in front of the establishment, they weren't there for long, or they went inside to the next door establishment, or they were just walking down the block.
Okay. And did you observe whether the sidewalk was wide enough in front of the establishment such that it would facilitate queuing and then also still allow foot traffic to pass by unimpeded?
So you're asking.
Basically, is it double wide? Is it big enough to allow a queue and still have people walk past on the sidewalk without having to step into the street? Did you observe that?
Oh, did I observe patrons able to walk through freely without having to step into the street?
Sorry. Did you observe whether the width of the sidewalk in front of the establishment is sufficient that it would allow a queue to form outside the establishment, right? Which one is what one might expect when And still, if a queue were there, allow foot traffic to pass by freely without having to step into the street. That's what I'm trying to figure out. If you observe, if you measured, observed, assessed, etc.
So that's a two-part answer. First one about the width of the sidewalk or the square footage or anything along those lines, I would have to defer that to DCRA. But as far as patrons being able to walk the street or walk around or anything along those lines, it's hard to tell if a patron is unable to walk through freely often on 9th Street if they're just walking in all different directions. And if you have the street blocked off from the Mayor Task Force, it's easy for a patron to just decide to walk into the street where there's no cars. So it's hard to just assess and just say that they're being blocked off if they're wanting to go to the other side of to the other establishments and just maybe just decided to get off the sidewalk at the time that someone else is approaching and go to the other side of the street. So it's hard to.
Okay, that's fine. Thank you. And I'm going to turn back to parking briefly. When the task force is blocking the 1900 block of 9th, I believe you indicated that there are other areas where patrons may be able to park nearby. Is that accurate?
Yeah, that's accurate.
Okay. And are those streets in the immediate vicinity residential streets? Are they commercial streets? Where is it that these cars would be parking?
I would say residential, mixed use areas as well.
Okay.
It's a mixture.
Got it. But they certainly aren't able to park on the 1900 block itself, correct? So the availability of parking is substantially reduced during weekend hours when these establishments are most frequented. Is that accurate?
The 1900 block, I would say, is unless they're there before the mayor's task force, and they cannot park on 1900 block. But 1800 block and further down, they are able to park.
You mean on areas like the lettered streets? Is that what we're talking about? South, essentially?
So 1700, 1800 block of 9th Street, they do not block off that street, one block down from the 1800 to 1900 block of 9th Street.
And are you aware that the Westminster Neighborhood Association's boundaries include exactly those blocks that you just identified?
I am unsure.
One last question for you. I think I heard you say previously that there were, based on your assessment, no schools in the area. Is that accurate?
Excuse me. According to the GIS map, yes, sir.
Okay. And what radius approximately? I'm not asking specifically, but can you tell me sort of if you were to put a center point at the 1900 block of 9th, what was the kind of the radius of that?
That would be a 400 feet radius, I believe. Excuse me. Trying to look at the map. 400 feet.
That gives me an approximate idea. So are you aware that roughly 2 blocks south and 1 block east of the 1900 block is Garrison Elementary School?
I'm going to object on relevance grounds. The statute calls for disclosure of schools within a 400-foot radius, which is part of the report and on the record.
And Mr. Starkland, I'm going to sustain the objection. I mean, unless you're questioning the radius that was provided, it's irrelevant where the school is if it's not located within the radius.
No, I was trying to clarify the radius, but it wasn't abundantly clear to me, at least at first, what the radius was. That's why I was asking. But that's fine. Then in that case, I have no further questions.
Thank you, sir. Any questions, any follow-up questions by any board members?
Can I ask questions, Chairman?
I didn't think you were asking questions, Mr. Bear. I mean, remember, we only have one designated representative, and that is Mr. Stockline. I gave the ANC an opportunity, but I can't have two quote-unquote attorneys testify, asking questions of the same witness.
Mr. Chairman, I'd just like for the record to clarify that I'm, while I am an attorney by trade, I am not representing Mr. Neighbors Association my capacity as such.
I said, Mr. Stockline, based on the way the process is, we have one designated representative, which you are representing both the ANC and your association, and that's by statute. And I did allow the ANC to have an opening statement. However, I'm not going to allow, unfortunately, the ANC to ask any questions. We can't have in these proceedings. When I said we do not have two attorneys questioning the same witness, so it's only one person can question the witness. What we actually
Is ANC want to be a party to this protest, though? We filed our own letter. We did our own votes. We said in the PIF we wouldn't be calling witnesses, but this is a witness that ABRA itself has put forth. I would just like a 1 to 3 minute line of questioning, and that's all you'll hear from me today.
Mr. Bay, the way this matter, these proceedings are, by statute, the board, when there's more than one protestant, the board basically inform the protestants that you have to identify one person to represent the groups, which we have done that. And so by having the one person representing the groups, only one person is allowed to cross-examine each witness. So I'm sorry, sir, but you will not be allowed to cross-examine this witness, sir. Okay.
Things inconsistent with past protests I've participated in, where I've spoken, and the representative of the Group of Five or the Neighborhood Association have also spoken. So
not in front of me, sir. But if you have a pressing question, I will allow you to pass that question on to Mr. Stockline, and he can ask the question. But okay,
Mr. Stockline, can you ask the investigator to clarify on each of the 3 visits how many patrons were observed, because that wasn't clear, and it appears that his investigative report has never captured the establishment with more than a third of its allowed capacity. And I think it's directly irrelevant when the capacity is being increased so drastically that the investigative report has never had any observations of the capacity at its fullest, much less not even a third of. So
hold on. All right, the capacity currently is, from what I'm told, 74, I believe. What is the current certificate of occupancy?
78, sir.
78. Whatever decision, the DCRA is the agency that determines capacity. So whatever decision that the board will issue today will not exceed whatever capacity that's on their certificate of occupancy. So, and I believe that the investigator testified on the 3 occasions. I think the most amount of people he said he had seen in the establishment were 30. I believe that's what he testified to. He testified that there were 1 or 2, but I think the most that he has stated that he has seen was 30. So therefore, those questions were asked. And so we don't need testimony on that anymore. It's clear based on the investigator's report. What is it that he testified to the 3 times that he personally observed the establishment? Okay, so we're going to move on.
Mr. Chairman.
Yes, sir. Yes, sir. You're on. I can't hear you, sir.
Mr. Chairman, based on everything that you just said, I won't make an attempt to paraphrase Mr. Bena's questions, but and with all due respect, I would like to preserve for the record the following objection. Westminster Neighborhood Association objects to the apparent directive that protestants be required to designate one person to speak on behalf of, offer statements, examine, cross-examine witnesses of all protestants. My understanding of the statute certainly provides for the board in its discretion to request that the protestants do this. However, I don't recall that request was made, but rather that this was directed. And so I just want to object on those grounds and then move forward.
Your objection, your objection as stated. I do not have the regulation in front of me, but the regulation clearly states that the board has the authority to the board has the authority to mandate that when there's more than once there's more than one protestant, that one party be designated as a representative.
With all due respect, Mr. Chairman, and I'll just quote directly from the statute, which I in fact do have in front of me, 16.
And what section? What section of statute you're reading, sir? Can you please?
1612.8. In any case where there, and I quote.
Hold on. You can't do 16, sir, if basically it has to be 23 or 25. So I'm not quite sure. It's either, I'm not sure where you're getting 16 from. It has to be 23 or 25.
Perhaps I have an incorrect statutory reference, Mr. Chairman, but the text of the statute that I have in front of me reads, in any case where there is more than one protestant, the board in its discretion may request that the protestants designate one person to conduct the protestant's case, et cetera, et cetera. I'll emphasize may request. I don't intend to belabor this point though, Mr. Chairman. I just simply wanted to preserve this objection for the record and understand and respect whatever decision you make.
Fine, thank you. All right, thank you very much.
Okay. No further questions.
Mr. Miller?
Yes, sir.
Thank you for your testimony, sir. Have a great day.
Thank you, sir.
All right. The 3:57. We're going to be off the record for 10 minutes. I'd ask that for it's 4:10. We will the licensee will put his case on, so we're off the record for until 4:10. We're back in the record. Mr. Stockline, are you there?
Yes, Mr. Chairman.
All right, thank you. Mr. Bianco, do you have a witness you wish to call?
Yes, I do, Mr. Chair. I'm going to call DeReggie Daniil, the owner of the establishment. And if it's okay with you, I'm going to pivot my laptop here so that you can see him and I won't be in frame.
Sure. All right, Mr. Daniil, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
Yes, I do.
All right, just raise your voice up, sir. I'm your witness, sir.
Yes, I do.
All right, thank you. Your witness, Mr. Bianco.
Mr. Daniil, can you spell your name for the record, please?
Dereje Daniel, D-E-R-E-J-E. The last name is Daniel, D-A-N-E-A-L-E.
Okay. And you're familiar with the establishment known as VIP Lounge?
Yes.
Okay. How are you familiar with it?
Owner.
Okay. And do you have any other co-owners in that business?
No.
Okay. And where is that business located?
1926 9th Street, Northwest.
Okay. And can you describe what the building looks like?
It's yellow with dark and 2 floors.
I can't hear you, sir. Can you raise your voice, please?
Yellow and dark, 2 floors.
Okay. And how many entrances and exits are there to the building?
3.
Okay. And can you describe where they are?
The first floor, the main 9th Street entrance. The first floor, the same time, in the back door in the alley. And the second floor in the back door alley.
Okay. And are any of those doors kept locked during business hours?
No.
Is the business presently operating?
Yes.
Okay. How long has it been operating?
Since March.
Okay. And that's March of 2022?
Yes.
And when did you purchase the business?
It's October's.
Okay. Could you say that louder, please?
It's October's.
Okay. And that's October of 2021?
Yes.
Okay. So between October of 2021 and March of 2022, when you actually opened for business, what were you doing with the property?
To renovate it and make it more soundproof and upgrade it.
Okay. And what type of license do you presently have?
Restaurant license.
Okay. And do you have endorsements on that license?
We do.
What endorsements do you have?
Entertainment, cover charge, DJs.
Okay. Do you also have do you have a dancing endorsement?
Yes.
And presently, what are your hours of operation?
11 to 1:30 a.m. Thursday to Sunday, and Friday, Saturday, 11 a.m. to 2:30 a.m.
Okay. And how late does your entertainment endorsement go?
Until the license 11 to 1:30 a.m. and 2:30 a.m.
Okay. And you are applying to make those hours later by 30 minutes, is that correct?
Yes.
Okay. And increase in occupancy?
Yes.
And what are you increasing in occupancy to?
To basically was in a restaurant. He had 30 people was sitting. So we increasing to the occupancy because of to sell more liquors and more incomes.
Okay, but how many people are you going to increase the occupancy to?
185.
Okay, and how did you get to that number of 185?
Based on the people we know, the knowledge for based on occupation for a building, based on a size.
Okay, did you hire anyone to come up with that?
Yes.
Okay, and what type of person did you hire to arrive at that number?
Before applying this license, supposed to be go to the DCRA. So I want to know the knowledge, what number be capacity be fitted this building. That's the conclusion to get the person to give you these numbers.
Okay, and has the certificate of occupancy been issued yet for 185 people?
It's not issued yet.
So can you describe for the board how your operation runs now?
We open, the license was 11 to 1:30 a.m. and the weekend 11 to 2:30 a.m.
Okay.
Based on the license, I never violate the license. I never pass the time to operate the business.
Okay, but what time do you open for business on the weekdays?
4 p.m.
Okay, and when you open for business at 4 p.m. on the weekdays, what services do you provide?
We do foods. We had a food menu. In the weekend, we open around 12 p.m. We had a brunch that's provided for the business.
Okay, and are you open later into the evening after dinner service?
We open the kitchen until closing.
Okay, so the kitchen operates till closing, but what other services does your establishment provide between after dinner time until closing?
So nightlife, DJs.
Okay. And where does that portion of your operation take place?
The second floor.
And what services do you provide on the first floor of the building?
Restaurant, foods.
Okay. I am going to, Mr. Chair, ask your permission to be able to share my screen while I go through exhibits.
Mr. Oriana, can you allow Mr. Bianca to share screen, please?
All right. Can everybody see what I'm sharing?
Yes, sir.
Okay. So, Mr. Daniil, I am going to show you a document that we are going to identify as applicant exhibit 1. And for the board's benefit, all of our exhibits are numbered in the lower right-hand corner. There are page numbers, so it's page number 2. So it's applicant 1, page number 2. Do you recognize that, Mr. Daniil?
Yes.
And what is that?
In front of the business.
And is that how it looks today?
Yes.
Move admission of applicant number 1.
I'm sorry, what did you say, Mr. Bianca?
Move admission of applicant number 1.
The start line? Any objection?
No objection.
Okay.
So moved.
So now I'm going to scroll down to page 3, which we are going to identify as applicant number 2. Where is that within the establishment?
The first floor, and this is the seating side.
Okay, so How is the ceiling of the first floor built out?
Basically prepared to work and to not any noise came out the building, to made it like 3-step thick ceiling.
Okay.
And some utility under a ceiling too. And at the same time, we have sprinklers all the entire house.
Okay. Move admission of applicants number 2.
Any objections?
None.
So
Okay.
moved.
We're now going to go on to page 4, which we will identify as applicant exhibit number 3. Where is that within your establishment?
It's first floor restaurant.
Okay, and what does it show?
Show the seating area.
Okay, and I want to focus your attention on the brick surrounding the pictures. Do you see that?
Yes.
Okay, and what's on the other side of that wall?
We fix it, probably 4 feet, 4-inch to the brick to in the wall. I put in new soundproof, and top of it, I using wallpapers.
So I'm asking you a different question, so we'll get there, okay? But do you see that brick wall there?
Yes.
What's on the other side of the brick wall?
Next establishment.
The next establishment. And what does that establishment do?
It's restaurant.
Okay, is there any residential at the
No.
neighboring establishment?
No.
Okay. Now, I want to focus your attention on the decorative area around the bricks, and I think you started to testify about that when I stopped you. So can you please describe what that is?
Yeah, we basically after took over, I put on some 2x4 and beside to the wall, the brick building, and I put on the soundproof in the middle to using cover up, and after that I use the wallpapers.
Okay. So how thick is that decorative area built out from the wall?
I think probably 4-inch.
Okay. Move admission of applicant number 3.
Any objections?
No, Mr. Chairman.
So moved.
Okay, moving on to applicant 4, which is identified as page 5. That is another picture of the build out surrounding the brick. And again, I want to focus on the thickness of the build out. How far is that built out?
4-inch.
Okay, move admission of number 4.
Any objections?
None.
Okay.
Without objection.
I'm going to show you a document that we are marking as Exhibit 5 or Applicant 5. It's on page 6 of the packet. And could you tell me what that shows?
That's the soundproof. I made it. You can see the foam and thick to soundproof. I using before to cover the wall.
Okay. And where is that photograph in relation to the decorative built out area?
The first floor.
Okay. Move admission of applicant number 5.
No objection.
Without objection.
Okay. All right, we're going to move on to page 9 of the packet. And we're going to mark this as applicant number 6. Do you recognize that?
Yes.
And what is that?
This is the first floor. On the left side, take you the bedrooms.
Okay.
On
Okay, so the first floor, right? Which direction is this photograph showing? The 9th Street side or the alley side?
in the back of the alley side.
Okay. And on the right-hand side of the photograph, I see some yellow tiles. What's there?
That's part of a kitchen.
Okay. And on the left-hand side here, I see a dark area. What's there?
That's for a restroom.
The restrooms. Okay. Move admission of applicant number 6.
No objection.
Without objection.
Okay, moving on to page 10, which we're going to identify as applicant number 7. Is that also the first floor?
Yes,
And which direction is that photograph shot in?
this is the 9th Street, the front side.
Okay, move admission of number 7.
No objection.
Without objection.
So we're going to go to page 11, okay, which we're going to mark as applicant number 8. What does that show?
This is the first floor preparation bar.
Okay, and I see there are no bar stools in that photograph. Do you use bar stools at that bar?
No,
Where do you provide alcohol service on the first floor of the establishment?
we serve alcohol upstairs, but we prepare on the first floor the picture of to see the little bar.
Okay, and if I'm sitting on the first floor and I want a drink, can I walk up to the bar and get one?
No,
Okay. Move admission of applicant number 8.
No objection.
Without objection.
So we're moving to page 13, and we're going to mark this for identification as number 9. What does that show?
this is the kitchen.
Okay. How many rooms are there in the kitchen?
2.
Okay, and is this, which room is this of the kitchen?
The first one, and we have more utility put on the
Okay.
kitchen.
Now, directing your attention to the upper part of the photograph where I am pointing, underneath the exit sign, there's a red door. Where does that door lead?
That is an emergency exit door in the back
Okay.
alley.
Go ahead, you can finish your answer. I apologize.
The back alley.
And is that door kept open or locked during business hours?
We need business hours always open.
And directing your attention to the front room of the kitchen where we started, what kitchen equipment do you have in the front room?
We have fryers, grills, stoves, and pizza stoves, and a preparation for foods and refrigerators.
Okay. And do all of those kitchen components function?
Inspected and functional.
Okay. And move admission of applicant number 9.
No objection.
Without objection.
So we're going to go down to page 18, and which we will mark as applicant number 10. What does this show?
This is part of the kitchen.
Okay. And is that the second room of the kitchen?
Yes.
And what's there?
You have plates, preparation rooms. Same time, you have a walk-in closet, freezer, and you have dishwasher, you have ice machine.
All right, I'm going to move admission of applicants number 10.
No objection.
Without objection.
Okay, so now we're going to go to page 19. We're going to mark as applicant number 11. It's another photograph of that second room of the kitchen, and I am pointing to a red door along the side wall there. What is that?
That is the office and all the camera system you put on it.
Okay, move admission of number 11.
No objection.
Without
Okay.
objection.
Moving on to page 20. Can you describe what that is?
This is the office and all the video system control.
Okay, and how many cameras do you have?
16.
Okay, where are they located?
I was first floor, second floor, outside, in the back alley.
Okay. And how long is that system capable of storing video footage?
30 days.
And did that system come with the business, or did you install that yourself?
I installed the new system. It's very upgraded.
Okay. When did you install it?
when I start a business, when I take over.
Okay, so we're gonna move admission of number 12.
No objection.
Without objection.
Okay, so now we're gonna go down to page 27. And we are going to mark page 27 as Exhibit 13. What does that show?
This is the back door,
Okay,
emergency exit.
and that leads
Take to the alley.
Okay. And that rear wall of the building where the white tile is there, how thick is that built out?
Probably 6-inch.
Move admission of applicant number 13.
No objection.
Without objection.
All right, we're going to go to page 30. And we're going to mark this as number 14. And that again is a picture of that front room of the kitchen. Can you tell how long that room is from front to back?
The first room approximately is 15-inch feet.
15 feet, okay. And have you measured that space?
Yes.
Okay, and does this truly and accurately depict the length of that space?
Yep.
Okay, move admission of applicant 14.
No objection.
Without objection.
Moving on to page 31, I can represent to you that this is a photograph of the second room of the kitchen. And do you know how long that room is from front to back?
Yeah, we measured before, it's gonna be 32 feet.
Okay, and does that truly and accurately depict the
Yes.
size of the second room?
Yes.
Okay, move admission of applicant number 15.
No objection.
Okay,
Without
so
objection.
Mr. Daniil, if you are granted this substantial change, how are you going to change your operation of the first floor?
It's gonna be the same thing. There is nothing to change in the first floor. We serve the food. We had a seating. The reason why I asked this, we want to sell more liquors, then you need space. That's the reason we asked the occupation.
Okay, and do you have a sense of where within the property you would be selling the additional liquor?
No.
Do you have any intention of making a bigger bar on the first floor?
No.
Do you have any intention of adding a dance floor on the first floor?
No.
DJ booth on the first floor?
No.
Okay. I'm going to show you a document that we are going to mark as number 16, which is page 54. So I'm going to scroll down a minute here. Okay, so I am showing you what we've marked as Exhibit 16 on the screen. Do you recognize that?
Yes.
And what is that?
Our menus.
Okay, and at what times of day do you offer that menu?
Since we open to closing.
Okay. And are those currently the offerings that you have today?
We do have a brunch menu.
Okay, well, what about this menu? Do you offer this menu in your restaurant today?
Yes.
Okay. Move admission of number 16.
Start line.
No objection.
Without objection.
So we're going to move on to what I'm marking as number 17, which is page 56 for reference. Do you recognize that?
Yes.
What is that?
That's the weekend brunch menu.
Okay. And when is that menu available?
Was it Saturday and Sunday from 11 a.m. to 5 p.m.
Okay. Move admission of number 17.
No objection.
Without objection.
We're going back to page 32, which I'm going to mark as number 18. Do you recognize that?
Yes.
And what is that?
We made the double door from protect the sound. Anything came out for a building.
Well, let me ask you this first. Let's take one step back. What part of the building does that show?
In the front.
Okay. And is that the main entrance to the building?
Yes.
Okay. Now, how many doors do you have there?
2.
Okay. Were there two doors there when you purchased the business?
No.
Okay. Did you add the second door?
Yes.
And which door did you add?
Middle one.
And why did you add that second door?
Make sure protect any noise not came out of the building.
Okay. Move admission of number 18.
No objection.
Without objection.
Okay. So now we're going to go to page 34, which we are going to mark as number 19. Do you recognize that?
Yes.
What is that?
This is the second floor to stair.
Okay. And is that the way that looks today?
Yep.
Move admission of 19.
No objection.
Without
Okay,
objection.
Going on to page 35, which we are going to mark as number 20. What does that show?
This is the second floors.
Okay. And which direction is that photograph shot in? The alley side or the 9th Street side?
That is the alley side.
Okay. And I am going to direct your attention to this green exit sign at the top of the photograph. What is that underneath that green exit sign?
That's the door. That is another protection. Nothing came out, the sound in the building.
Okay. Where does that door lead to?
It leads to 2 bathrooms and emergency exit.
Okay. And was that door there when you purchased the business?
No.
And did you put that door in?
Yes.
Why?
The first cue is to make sure nothing noise came out in the building.
Okay. So I am going to move admission of number 19. I'm sorry, number 20. We're on number 20.
No objection.
Without objection.
Okay, and now we're going to go to page 37, which is exhibit number 21. What does that show?
This is the same second floor, face to 9th Street.
Okay, and you mentioned earlier in your testimony that you did some build out to the property. What can you describe what build out you did there in that photograph?
Based on the building, make sure nothing, any noise came out. I put a foam behind the wall. After that, I cover wallpaper and some decorate stuff.
Okay, and that's that gold
Yeah,
material that you see there on the wall?
yeah. Still,
Okay.
still that you protect the sound too.
Okay. And when you say you put foam behind the wall, what do you mean?
Make sure that it's enough thickness to have protect the sound. Nothing came out in the building. Then after that, we put in for the wall. Then after that, put on decoration.
Okay, and what type of foam was it?
What is that? We bought from Home Depot, but what do you call? It's a big, look like plywood, but it's a foam.
Okay, so it was solid?
Yeah.
And you didn't put it, did you put any spray foam back there?
If you have any little space to open, we do foaming. Yeah, spray foaming.
Move admission of number 21.
Objection.
Excuse me, without objection.
Okay, so we're going to go to page 45, which we're going to mark as number 22. All right. And do you recognize that?
Yes,
And what is that?
this is the second floor emergency exit.
Okay. And is that ever kept locked during business hours?
The business hours always open.
Okay. And can you describe what the textured material is on the inside of that door?
So basically, we had a DJ upstairs try to protect the sound. I put the big foaming behind the door.
And did you install that or did the building come with that?
I did.
Okay, move admission of number 22.
No objection.
Without objection.
We're going to move to page 46, which we're going to mark as number 23. You recognize that?
This is the back side of the alley and trash
Okay.
stuff.
Is that how it looks today?
Yes.
What do you do to keep it clean?
Someone be to do every single day, pull out the trash inside the building, make sure he clean outside the building.
Okay. And how often do you have trash picked up?
4 times a week.
Okay, move admission of number 23.
No objection.
Okay.
Without objection.
Mr. Daniil, since you have been open in March, have you had DJs on the second floor of the property?
Yes.
Have you received any noise complaints during those DJ parties?
No.
Okay, now, Mr. Daniil, do you intend to have a security plan as a tavern?
Yes.
Have you prepared a draft?
I don't. My lawyer prepared.
Okay, so your lawyer prepared a draft of the security plan. I'm going to show you what begins on page 47. And we are going to mark as number 24. Do you recognize that?
Yes.
And what is that?
A security plan.
Okay. And you said your lawyer prepared it, right?
Yes.
Are you referring to me?
Yes.
Did you ask me to write it?
Yes.
Are you familiar with it?
Yes.
Okay, we're going to talk about a couple of the provisions. I want to look at page 47, item number 3. It says VIP will train staff on this plan upon hiring and adoption of any new version. Is that what you intend to do?
Yes.
And how are you going to do that?
Basically, when I hire security is more trained in companies. So whenever we hire any companies, we sit with them to review all the security plan, how to apply it to doing the security time.
Okay. And does this security plan deal with entry procedures?
Yes.
And what are your entry procedures to the establishment?
Based on the security plan to, to guide us to work on it to the security companies.
Okay. And what are you going to have them do when people enter the establishment? So what does that process look like?
The first, make sure pat down everybody. And the second thing, we had a warner to check to make sure no one have any materials to get in the building.
Okay. So what I heard you say is Warner. Is that what you mean to say?
Yep.
Okay. What's that?
To search in any materials to have it to search that materials.
Okay. What does it do? Can you describe for me what it does?
Basically, the security company and a government company use that to any guns, any knives, anything if you haven't to put anywhere to search with that machine, it tell you what you have in your body.
A wand. Are you describing a wand?
Yeah.
Okay. Okay. Sorry, I didn't understand what you said. That's my fault. How about ID checks?
Yeah, always when you open, make sure security is anybody to get a building to be over 21.
And do you know how many security personnel you intend to have on the premises?
We do.
Okay.
We have 5 securities.
And where are those 5 individuals going to be stationed?
So one of them staying in the door, one of them between upstairs and downstairs, first floor, and 3 of them is in upstairs.
Okay.
If
And how are you going to hire security? Are you going to hire people yourself, or do you intend to engage a company?
doing on companies, somebody have a company, an LLC, and well-trained companies.
And if I haven't already, I move admission of the draft security plan marked as applicant number 24.
No objection.
Without objection.
Okay. I want to go to the investigative report for a moment and ask you specifically about something in it. So I would like to look at page 3 of the body of the report. Okay, so did you have a conversation with Investigator Miller about this protest?
Yes.
Okay, and it says here at the bottom of page 3 and on to page 4, I am unsure why they are protesting my establishment. I ask them why they protest, and they don't have an answer for me. They use things that happen at other lounges to put us all together. That is not my establishment, so how can they bring that to me? One guy told me if I sell to this white guy, they will not protest. I couldn't believe he said that to me. Do you recall saying that to Investigator Miller?
I did.
Okay, is that an accurate statement that you gave that Mr. Miller wrote there in his report?
He's right.
Okay, now it says, one guy told me. Who's that person that you're referring to when you said one guy?
I'm glad he represents this hearing. He's there. He's a person. We had a good relationship with him. He know me well. I'm really negotiable person. He just came my business. We have a settlement agreement for a secret lounge. There is no violation since I signed it. He appreciate that. He knows I do follow the rules. He called me, said, are you the one able for secret lounge, the VIP lounge? I said, yes. He gave me the option. What he said, you have the white investors. He want to buy the license if he want to sell it. If he's not, there is no negotiable to be protest your license. Really irritated me and really upset. I say I never say anything to him. I just keep my mind and then left. And at the same time, I keep asking him why to push me to sell the license for somebody else, not protest. Why you protest my license?
Objection, hearsay, relevant.
It's an admission by a party. It goes to bias, goes to credibility, goes to the underlying facts of the protest letter, which contains no detail whatsoever.
I'm gonna allow, I'll allow it. I'm gonna overrule the objection.
Not only that, I can prove the text message what he texts me. Not only that, he told me if we testify against Empire, I'll let you go free. That is unprofessional to receive from him
And
as a leader.
when did this discussion take place?
The first conversation we start he called me, said, "Are you on the VIP lounge?" I said, "Yes."
Okay, when was that? When?
Probably October
Okay, of 2021?
2021.
And what was your response to Mr. Steckline's statements?
I was really, when I heard the first time, when he told me that, I was really mad. I don't want to say reaction to him, because why not approve? Why you want to sell for white people to being approved? That is the first question. The second question to me said, if we testify anything to know about Empire Lounge, to be let him go to be approved my license. I feel like I have interest conflict I think he's a chairman of the WNA something. He's a representative. He's the one he make me sign for the secret lounge settlement agreement. So that's, to me, it's not unprepared and professional way to deal with this.
Okay, so moving on from there, is there presently a roof deck at the establishment?
No.
Is there a summer garden anywhere?
No.
And that's not part of this application, correct?
No.
Okay, I don't have any further questions at this time. I am going to unshare my screen here, and the board, I'm certain, will have some questions for you.
Well, Mr. Stockline first, and then after then the board might have questions after that.
Mr. Chairman, as a preliminary procedural question, just ask for your guidance here. So as you might imagine, I'm deeply troubled by some of the statements that I'm hearing for the first time here, the allegations that are apparently being attributed to me. So I'm not really sure how procedurally you'd like me to
You're cross-examining him, so you're free to ask him. He made allegations, and you are free to ask him in a professional manner on the cross-examination.
I wouldn't imagine doing it in any other manner than professional.
You know what I meant. It's somewhat. You stated that it's personal, and so that's why I'm using the term.
I said it's troubling, but
it's allegation that's attributed to you, so it's somewhat personal. So that's why I'm using the word professional. So he's on cross-examination, and as long as you are professional in cross-examining him, I will allow reasonable cross-examination on everything that he testified to on the direct.
Okay, thank you, Mr. Chairman. DJ, are you, since you already testified that you and I know each other, which we do, are you okay with me just referring to you as DJ?
Yes.
Okay. DJ, you hold 3 ABC or ABRA licenses, correct?
Yes.
And aside from VIP Lounge, am I correct that those licenses are a CT license for Secret Lounge? One of those is a CT license for Secret Lounge at 1928 9th Street Northwest. Is that correct?
I'm going to object to the line of questioning about other licenses held by the owner of this licensee, I have two grounds. One would be relevance, as the question here is the appropriateness of this particular and not other establishments. And second, there was no direct testimony about other licenses held, or no questions on direct about other licenses held by Mr. Daniil, so it's beyond the scope of the direct.
I'm sorry, I couldn't hear the last part of what you said, Mr. Bianco.
Relevance and beyond the scope of direct was really the bottom line of the objections.
Mr. Chairman, the board has found on countless occasions that when there is an applicant who owns multiple licenses, establishments in the city, that those cases and the conduct of the applicant in managing those establishments is highly relevant. That is particularly the case here, where as the investigator observed, as the applicant has, I believe, even acknowledged, the establishment about which this question to which this question just referred is directly next door.
And
Go ahead.
Mr. Stockman, have you had any dealing with him regarding how have you had dealings and conversations with him regarding other establishments on the same street?
Well, in my capacity as the delegated representative of WNA, the instances in which I've communicated with DJ are those where I've had to serve notice of the WNA meeting or protest petition on DJ personally. And we've had occasion to discuss, as DJ also explained in his own testimony, which opens the door, of course, to this line of questioning. We have historically had a good relationship together, and in fact negotiated the only settlement agreement that I've been a part of negotiating on the 1900 block for Secret Lounge, in fact. So that's the extent of my.
All right, I'm going to overrule the objection, but again, this is about the appropriateness of this establishment, the VIP lounge. I'm not going to. Yes, we can have testimony about other establishments on the block that he owns, so the board can make a determination whether or not his operation of these other establishments, how he operates these other establishments. But again, this is about VIP lounge, so I'm not gonna allow extensive testimony on other establishments, but I will allow some. Okay, so go ahead, sir. But we're not gonna have an hour talking about any other establishment that he owns. The cross-examination should be focused on this establishment, and if you want to bring in a tie between how he operates another establishment, yes, you can do that, but we should not be spending a significant amount of time on any other establishment.
But that understood, Mr. Chairman. All I was trying to establish my question was whether DJ owned the establishment next door and would acknowledge that. I haven't even gotten to the heart of the matter. So
I know, but I'm also cautioning you that I'm not going to allow us for you to cross-examine him an hour on another establishment.
I have absolutely no desire to do that.
Okay, fine. Go ahead, sir. So I'm overruling the objection. All right.
Thank you. DJ, let me just repeat the question. Aside from VIP Lounge, am I correct that one of the CT licenses that you hold is for Secret Lounge located at 1928 9th Street Northwest?
Yes.
Okay, and that is next door to the address under consideration today, correct?
I own the next door VIP Lounge, yes.
Okay. And the third and only other CT license that you hold is for Signature Lounge at 1727 Connecticut Avenue, correct?
Yes.
Okay. Can you tell me, can you compare or describe to us the operation at Secret Lounge and how it would compare to what you intend to, how you intend to operate at VIP Lounge?
Basically, I'm not only the person who run couple lounge or restaurant in the city. Anybody can hire in professional people and the ABRA qualification manager license to operate the business. So basically we train the people. We had a license on the ABRA manager license to run a business.
Okay, so I believe you said that just a second ago. You told us that Secret Lounge is a model for your intended operation of VIP. Is that correct?
Yes.
Okay. Now, for Signature Lounge, is it correct? Is it accurate that the board just granted you that license last year?
I'm going to object. The last question that was objected to and the board ruled on dealt with an establishment immediately next door. The line of questioning now is turning to an establishment several miles away. So I think the relevance objection is especially important, not to mention the fact that there was absolutely no mention of anything related to Signature Lounge on direct, so that it's beyond the scope and not permissible to inquire into.
Mr. Starkland, where are we going with this?
Well, Mr. Chairman, in response to Mr. Bianco's objection, and I'm quoting directly from a board order now, when establishments have overlapping ownership and shared management, it may be relevant to whether the new owner will operate the establishment without a detrimental impact on the neighborhood, end quote. In this case, go on, the board has serious concerns with Secret Lounge, et cetera, et cetera. I'm simply trying to, based on the board's own precedent, bring forward facts that are highly relevant to instances of shared ownership and DJ's operation of those establishments. I want to make sure that the board is aware of those, since the board has taken notice of that and other proceedings on the same grounds.
But one of the problem we have here, sir, remember, irrespective of what decision the board makes today, he has a license. He has a CR license. This is not an application for a new license. He's asking us to change the license category from a CR.
I couldn't agree more, Mr. Chairman.
Right. So from a restaurant to a CT. So, but what I'm trying to say though, so even if the board was to grant your petition to deny the change, he's still going to own he still has a license. He's still going to operate.
We understand, Mr. Chairman. In fact, we've invited him to please continue operating the restaurant. So that's not a concern of ours. We wish he would.
But one of the major differences between a CT and a CR is that he doesn't have any reporting. He no longer has reporting requirements to the agency. So therefore, I'm just saying that's one of the major differences, in the sense that the percentage of food that you have to sell, so he can continue selling as much or as little food as he so desires.
Mr. Chairman, with all due respect, from the neighborhood's perspective, the major differences are substantial increase in capacity, operation to the fullest extent of legal hours permitted in the District of Columbia, live entertainment, dancing, etc. So I would submit to you that They're actually the changes here are in fact quite significant. It's
No,
ostensibly
you're not listening to what I'm saying, sir. I'm just talking about the category itself, okay? I'm not talking about the other substantial change in the sense that he's asking for the increased hours. I'm just saying that from a practical perspective, just one of the major changes from changing from a CT to a,
yes,
I'm sorry, from a CR to a CT, it's the reporting requirements that is the reporting requirements to the agents in the sense of the.
I understand, Mr. Chairman. I'm not sure that
that what, sir?
That's not really where I was intending to go with this.
I hear you, sir, but I'm just trying to point out to you that irrespective of what irrespective of what decision the board makes today, he will still have a CR restaurant. He will still, even if the board doesn't grant this,
I'm aware, Mr.
Today,
that's I don't dispute that in any way, shape, or form. I'm not sure I understand.
I'm just saying to you that I don't know where we're going with that line of questioning, and so I need you to focus on the VIP lounge. I gave you some leeway that you can focus on an establishment next door because it's within. I don't know about the secret lounge you're talking about. I don't know where that is, and I'm not quite sure where we're going with that.
Well, Mr. Chairman, in DJ's testimony, you've just heard him say twice that Secret Lounge provides a model for his intended operation of VIP Lounge. So that's directly relevant. I'm asking him to compare things. You know, I was hoping to. I was trying to get him to compare.
All right. I'm gonna overrule the objection, but I need you to, and I need you to get to the heart of what the issue, this protest hearing, sir. Okay. Okay. Go ahead.
Okay. DJ, are you familiar with the board order issued in which it granted you the Signature Lounge license on August 26, 2021?
Yes. Yes.
Okay. And in that order, are you aware that the board made certain findings of fact based on testimony and evidence?
What is the fact?
Okay. Are you aware that one of the factual findings was that on a particular occasion, after disputes started inside that the establishment locked its doors and prevented police from entering?
I'm going to object to this line of questioning on several grounds. One, I'm not sure what establishment he's talking about. Number two, it assumes facts that are not in evidence. Number three, a board order that is being contested as to the facts is not an appropriate subject matter for the board to take official notice of, and no exhibit has been proffered for this particular issue. And not to mention the Signature Lounge is several miles away, and the precedent that Mr. Steckline was citing is the Shadow Room case, which I think, as the board is familiar, deals with establishments that are housed within the same building. So I certainly understand the board's ruling on the Secret Lounge directly adjacent property, but now we're straying into Signature Lounge, which is several miles away and not relevant to the considerations in this case.
In response to Mr. Bianca's objection, I would start by saying I'm simply asking in this question whether DJ is aware, most basically speaking. I would also submit that contested status is irrelevant in this instance, although the appeal is pending. This, by the way, is with respect to the Signature Lounge case. The board's order has not been stayed pending appeal, so it does constitute final board action and remains in effect. There's no reason it can't be relied upon here. And in fact, the board has said quite specifically that again, facts pertaining to other establishments under common ownership can be relied upon. If Mr. Bianco would prefer to continue this protest hearing until after the Court of Appeals rules on the signature line appeal, WNA would have no objection to that continuance. So if, Mr. Bianco, if you'd like to make that motion, we would welcome it.
I would like to correct your flatly wrong statements of law and provide the board some precedent by which they can actually decide the issue within the confines of the Administrative Procedures Act.
Well, I'm sure that you'll have the opportunity to do that, but I actually am not finished with rebutting your multitude of extensive.
All right, gentlemen. Okay. All right. Hold on. All right. This is all right.
I would appreciate the opportunity to finish, Mr. Chairman.
I'm gonna overrule the objection, but as I've stated, sir, this concerns the VIP lounge. I'll allow you limited questioning, but we're not gonna spend the entire afternoon speaking about other establishments because we're moving too far afield of this issue. Based on what was stated by counsel, you're asking questions that were not raised on the direct cross-exam, on the direct. But I'm giving you some leeway, but I'm gonna shut this off if we continue going down this road. The question is he aware of these factual situations? Yes or no? Are you aware of it, sir? If you're aware of it, says yes. If you're not aware of it, say no, and let's move on.
Okay.
That's a question pending.
I'm sorry, are you asking me a question or are you?
That's the question you asked the witness. I'm directing the witness to answer the question based on what was asked. You're asking him a question. Was he aware of these factual, you'd ask him a factual if he was aware of the facts in a case.
Mr. Chair, the witness has asked if Mr. Steckline can restate the question.
All right.
Okay, just to be, I'm going to try to be abundantly clear here because I know we're dealing with 3 different names, lounges, and 2 of them begin with an S. My intention for everybody here, to be clear, is I am attempting to cite from Signature Lounge where the board accepted testimony about secret. I am simply trying to replicate the exact same scenario here. Accordingly, I will repeat the question. DJ, are you aware in the board's finding of facts of a particular occasion in which, after a dispute started inside Secret Lounge, the establishment locked its doors and prevented police from entering?
I'm not sure.
I'm sorry, could you repeat that? You're not sure?
He's not sure.
I'm not sure.
Okay, so you.
Let's move on, sir. He said he's not sure. Let's move on.
Okay, got it. Are you aware in the board's order of the conclusions of law that were made?
Yes.
Okay. And so is it accurate that you're also aware in the order the board said, and I quote, they were concerned about your ability to manage a nightclub, end quote?
I'm going to object again. We're now talking about Signature Lounge, several miles away. He's not talking about Secret Lounge. And in this case, per the Court of Appeals ruling, although an administrative board has the right to take notice of certain pieces of the administrative record, that is subject to that the fact must be one that is not subject to reasonable dispute. Here, Mr. Steckline is not only referring to facts that are in dispute, but that are the subject of a Court of Appeals case that is pending oral argument. And the specific citation that explains the concept of judicial notice and when it's appropriate in its entirety is Christopher versus Agugi, 841, a second 310, DC 2008. It also references the Administrative Procedures Act, DC Code 2-509B, and principally relies on an agency case called Mannin versus Board of Medicine, 558, a second 329 and 338, which is a DC case for 1989. Our position is that the Signature Lounge case, several miles away, is not only not relevant, it's not appropriate to inquire into because of the constraints of the Administrative Procedures Act and Court of Appeals precedent. And Mr. Steckline's effort to use his words to replicate what occurred in the Signature Lounge case possibly could have been done if he survived a relevance inquiry by putting on actual witnesses like they did in the Signature Lounge case. But we don't have those facts here.
And I'm going to sustain the objection. There's one statement that you made, sir, about his operation of a nightclub. This is not a nightclub. He's requesting a CT, a tavern. And there is a significant amount of difference between a tavern license and a nightclub license. He's not requesting a nightclub license from us. So I'm sustaining the objection. Let's move on, please.
Mr. Chairman.
Yes, sir.
Can I have an opportunity to respond to opposing counsel before you rule on the objection?
No, this diatribe has gone on for over 5 minutes. Let's move on, sir.
Yes,
So let's move on. I need you to give the board information that will aid us in whether or not we're going to grant or deny the substantial change. That's what I need. Relevant information.
I'm desperately trying to do that. And I think that Mr. Bianco has unfortunately confused the statements that I'm citing. The statements I am citing from are from the Signature Lounge order. However, the facts being addressed in the citations that I quoted they specifically pertain to the operation and activities occurring next door at Secret Lounge. So Mr. Bianco continues to suggest that Signature Lounge is 2 miles away. I don't disagree with him. That's irrelevant. What I'm speaking to, by virtue of using an order of which the board's own order, and therefore an order I would have expected the board to be willing to take judicial notice of, I am simply trying to leverage facts that are not in dispute and pertain to the building immediately next door.
But that's fine. I mean, that is fine. You can make arguments about in closing. These are appropriate. You can raise these in closing, but you're doing cross-examination. You're asking him questions that were not brought under direct. You're asking him if he's aware of it, and I don't see where we're going with this. I mean, I understand if you want to make arguments in closing, you can talk about his behavior, why you believe that he's not going to be a good operator, but currently you're asking questions on, this is direct. I'm sorry, this is cross-examination. And prior to you raising this on a cross-examination, I'm not aware that he was the owner of Secret Lounge. I'm not aware that he was the owner of
Well,
Signature
Mr. Chairman,
Lounge
this was in your own investigator's report. It was explicitly stated. The investigator just testified to it. I don't understand how you're not aware of that, sir.
Let's move on. I've made my ruling. Let's move on. If you disagree, you can appeal it. Let's move on, sir. We are not getting anywhere. I want the parties to bring relevant information that will help the board in making a decision on this substantial change.
Mr. Chairman, if we're denied due process at every turn of the road, then I don't even see how any of this is relevant.
Mr. Chair, they've had the opportunity.
I've made my decision. Let's move on, sir. Ask another question, or either ask another question, or then let's move on with this case. I'm not going back and forth. So I've made my ruling. Let's move on. You can, if you want to state an objection for the record, but let's move on.
Okay. DJ, in any of your existing CT licenses, has the board seen fit to impose conditions or restrictions on those licenses?
Same objection.
I'm going to overrule the objection. If you can answer the question, you can. If not, let's move on. Answer the question, sir, if you can.
DJ, I'll just ask the question again. In any of the licenses that you currently hold, the 3 licenses that we've just discussed here, do you have any conditions or restrictions placed on them?
You can answer the question, DJ. Go ahead.
I'm sorry, I can't hear you, DJ.
I believe, I think even I have 2 licenses based on my record. You know me.
I'm just asking a yes or no question, DJ. In either Signature Lounge or Secret Lounge or VIP for that matter, are there conditions or restrictions placed on those licenses that restrict your operations in any way?
I mean, the case is open.
Mister, you can't ask your lawyer, sir. You either, if you can't answer the question, say I can't answer it. You can't look at your lawyer. Just answer the question if you can. If you can't, you can't.
Okay, I cannot answer this question.
Next question.
So I just want to make sure I'm clear. So you are unaware of, you are currently operating both at Signature Lounge and at Secret Lounge, but you are unaware of the conditions of those licenses?
Objection asked and answered, mischaracterization, relevance.
The applicant should, without a doubt, if operating any establishment under ABRA's authority, be expected to know whether or not those operations are subject to restrictions, requirements, or whatever else.
If you have the restrictions, sir, can you ask him if he's aware of the specific restrictions that are placed in his license?
I can. DJ, with respect to Signature Lounge's operations, are your hours, is it correct that your hours are limited Sunday through Thursday to ceasing at 1 a.m. and 2 a.m. on Fridays and Saturdays?
Yes, based on now, yes.
And for my own edification and clarification, is it therefore correct that that this means you are required uniquely to end your operations an hour earlier than the closing time otherwise permitted under DC law?
Objection, compound.
Are you, I'll withdraw and rephrase the question.
Wait.
Are you required to close, to shut down your operations on Sunday through all days of the week an hour earlier than otherwise required under law?
Already I answered a question.
Well, I think I was asking the dates and the times, and so now I just want to make sure that I understand.
I'm going to object as calling for a legal conclusion. The law says what it says, and Mr. Steckline is free to argue what he would like about it, but my client does not have to opine on it.
Well, I'd like to know, first off, if he actually knows the law, because that is highly relevant to whether or not he intends to abide by the law. And if he does know the law, I'd like to know whether the conditions imposed under this permit actually, in his mind, reflect a difference with the law.
But Mr. I'm gonna sustain the objection. I think one of the things that you're also missing, sir, even in his license application here, he's not asking for full hours. So you're saying that, was he aware that in a different case that the board, for whatever reason, had given him shorter hours, but even in this case, he's not asking for full hours. So I don't know why the board. Well,
Mr. Chairman, I will follow your instruction, and I will provide the explanation given by this board in that proceeding in my closing. But what I am trying to solicit testimony on is, or what I'm trying to demonstrate is that it is very hard for the neighborhood, and I would expect this board to trust that the owner will operate in compliance with conditions and restrictions on that apply might be applied to VIP Lounge if he's not even aware of them or operating them currently when they apply to his existing establishments. Right? There's a pattern of behavior here that's very important for the commission to consider. It has deemed it appropriate to do so previously. I'm simply trying to clarify whether DJ even cares enough to pay attention to the restrictions that you've already imposed on him.
Is that a question that you're asking, sir?
No, it's I mean, there was an objection somewhere tucked in here from Mr. Bianco, and I'm responding to it.
I'm sustaining the objection. Let's move on.
DJ, are you prohibited from charging any cover charge on your Signature Lounge license?
Say that again.
With respect to your Signature Lounge license, are you prohibited from charging a cover charge?
No.
Are you prohibited from hosting live bands?
No.
Are you prohibited from allowing promoters or other third parties to operate or control the establishment?
Same objection. Mr. Chair, if appropriate, I would like to note a running objection to any and all questions about Signature Lounge 2 miles away, so I don't have to continue to interrupt, and I can let Mr. Steckline ask his questions. Thank you.
Yes, sir. Go ahead. Go ahead.
Okay.
I'm going to overrule the objection, but there's a running objection. Go ahead, Mrs. Stick.
Okay, DJ, you indicated in your statements made to the investigator, and then subsequently just elaborated on in prior testimony. Indicated that you and I met prior to today to discuss the WNA's protest in this proceeding, correct?
Say it again.
I believe you testified previously, it's a few minutes ago, or about a half hour ago at this point, that you and I met prior to today in order to discuss the WNA's protest against this application, correct?
Yes.
Okay. And do you remember why it is that we met?
First, he called me. You want to make sure I'm the owner of the VIP lounge.
Right.
I responded to you, yes.
Right. And do you remember sitting down with me in person at VIP Lounge on May 8th?
Yes.
Mm-hmm. And at that time, do you remember discussing with me whether you would consider continuing to operate VIP Lounge as a restaurant rather than pursuing a tavern license?
He didn't discuss that. He just dropped the letter from you guys to protest. Then the same time, you ask me a question, I'm responding to you.
Yeah, DJ, so I just want to clarify, is it your testimony today that you and I have never discussed Westminster Neighborhood Association's request that you consider dropping your request for substantial change and continuing to operate the establishment as a restaurant?
No.
DJ, in your testimony via Mr. Bianco, you provided us with, I didn't even keep count, but a multitude of photographs of the establishment as it exists today, and all of the expensive equipment and trappings of a restaurant that you have there today. You're correct?
He said equipment.
DJ, let me just rephrase the question.
Okay.
You showed us a heck of a lot of pictures about an hour ago of restaurant tables, chairs, tablecloths, pictures, restaurant equipment, correct?
Yes.
And that represents a significant investment. Is that correct?
Half of them, yes.
I'm sorry?
Half of them, yes.
Okay. And so, can you tell me, prior to your acquiring this space and this license, can you tell me how this business was operated previously? Can you tell me what it was? What was the business? What was the building being used for previously?
It's a restaurant.
Yeah, and can you tell me what kind of a restaurant?
Mix American and
I'm sorry?
American foods mix. We do chicken wing, fries, you know, when we see the menu, we provide more food now. We hire somebody in our kitchen. We do a brunch too.
DJ, do you remember the name of the restaurant that existed prior to your acquisition?
The previous owner?
No, the name of the restaurant.
Which restaurant?
The restaurant that you acquired that was located at the VIP Lounge address?
You want to ask me the address or the name of the restaurant?
No, I'd like to know that.
Do you know what's the name of the restaurant that was the business you bought? What was the name of the restaurant?
Al Castino.
Right. And how long had Al Cristino been operating in that space, to your knowledge?
Objection, relevance.
Overruled.
TJ, how long had Al Cristino been operating in that building beforehand?
I don't know how long.
Okay. Did you have any interactions with, relationships with the owner of that establishment prior to your acquiring it?
Very good relationship.
Okay. And had you spent time in the establishment beforehand? You ever visited it? I mean, if you had a good relationship, can you tell me about that?
I like Italian food. Always I eat over there.
Got it. Okay. So it was an Italian restaurant. You liked Italian food. You had a good relationship with the owner, so you went there. Can you give us an idea how often?
Probably
Where are we going? All right, hold on. Where are we going here? I don't think that's relevant. What? All right. It was an Italian restaurant. He had a good relationship. Why is it relevant how often he went there? I don't know where we're going. This is not helpful. This is not helpful. This is not helpful for the board to make a decision whether or not we're gonna approve a substantial change. I mean, this is a waste of time.
Well, Mr. Chairman, if you would let me continue.
But you have asked him. Well, I'm sorry, sir. You're asking him what type of restaurant. How long does he know the name of the restaurant? How long did it operate? What was his relationship? I do not know why we're going down this road.
Well, if you would give me an opportunity, Mr. Chairman, I could actually answer that question unless it's a rhetorical question, in which case you don't intend for it to be answered. Would you like me to provide an answer to that?
You do not need to ask 5 questions, sir, about whether or not he knows about this restaurant. He's requesting that we change the license category from a CR to a CT.
Mr. Chairman, I am trying to establish 2 things. Well, 3 things. However, because we don't have any evidences with which to do that, I can't impeach DJ's prior testimony. But the statement that the WNA never approached him to ask that he continue to maintain this, what was a fixture in the neighborhood, is patently false. In fact, Mr. Bianco observed one such occasion. But unfortunately, I can't impeach him on that. I'm also attempting to establish that given the long tenure of the restaurant in the neighborhood and the nature of the restaurant, which is what I was trying to deduce from DJ's testimony, is the change he is requesting, shifting from a neighborhood fixture, quiet Italian restaurant, to yet another tavern effectively operated as a nightclub, is not just a minor change. It is a significant difference, which will have a significant adverse impact on the community. Those are the things that we are able to speak to as the community. Those are the things that the board is, based on the statutory criteria, supposed to consider. But if I can't even speak to it, then I'm not able to make our case. And so for that reason, I can just cease that line of questioning too. DJ, when we met on May 8th, do you recall, as part of that conversation, me telling you that the neighborhood had become aware of a potential buyer of a business seeking, a significant business seeking a transfer of any existing liquor license on the block?
We never discussed that. Specifically, you don't even give me a chance to ask you a question to negotiate it. I said I'm negotiable. Do you have any problem with my?
DJ, it's a yes or no, actually. So I can
No.
rephrase the question if you like. Mr. Chairman, I would ask that you please instruct the witness to answer the questions and only the questions that have been asked.
Mr. Chairman, the witness gets to answer the questions.
He
as
does,
they're-
and it's a yes or no question.
As he deems fit. Council cannot direct the manner in which the questions are answered.
That is very true. However, the chairman can, and my request is that in response to a yes or no question of the witness accordingly respond with a yes or no.
All right. Ask him a specific question, sir, so he can only answer yes or no. You can't ask him a question that gives him an opportunity to explain. So if you want a yes or no, ask him a pointed question where he can only answer yes or no.
Understood, Mr. Chairman. DJ, when we met on May 8th, do you recall me telling you that the Westminster Neighborhood Association had been approached by a large business seeking to acquire an existing alcohol license on that block, on your block?
No.
DJ, Mr. Bianco read a statement previously that that you apparently gave to the investigator, indicating that a person, and then you elaborated that I had approached you suggesting that, I'm sorry, Mr. Chairman, I don't have this in front of me, so I can't read it. I'm not sure the best way to read back to DJ exactly what it is that's on the record, since I don't have any of these documents in front of me, but
is it in the case report that you don't, is it in the investigator's case report? You don't have a copy of the investigator's case report?
as I noted at the beginning, I was not served with any of this, so I'm just struggling here.
I'm not talking, no, I'm saying, so you do not have a copy of the, in that, I didn't say the document.
I do not. If anyone has available the particular statement to which I'm referring in the investigator's report, I'm simply trying to make sure that when I quote it correctly rather than paraphrasing it.
I'm sharing, to make it easier, I'm sharing my screen right now. I'm highlighting the quote in question from the investigator's report. It appears on page 3 and page 4. I just want to get through this.
Thank you, Mr. Bianco.
Absolutely.
Could you scroll down just slightly?
Sure. There you go.
Thank you. So, DJ, based on the document in front of us, you indicated to the inspector that one guy told me that if you sold something, it's not clear what that was, that they would not protest. Can you tell me what it is that you were referring to? What is it that this guy, allegedly me, suggested that you sell?
Yes.
What is it? What is the it?
What you say to me, I told the investigators. That's what he wrote it.
No, I'm asking you what the it is, just to clarify for the board. What is the it? Is it the license and that the liquor license that is attached to VIP Lounge?
Yeah.
Okay. So now I'm having a hard time understanding. So you told the investigator that you and I spoke about the potential for you to sell your license, but just 30 seconds ago, I believe I heard you testify that you and I never spoke about the prospect of selling your license to another business. Can you
It's
tell me
not.
which one is true?
Let me explain to you. This conversation is the first time when he called me on the phone.
DJ,
He
I'm
talked-
only asking about May 8th, when you and I met in person on May 8th.
When he made you the second time, the personal, he just brought the letters to drop me a protest license, protest letters. That's only me the second time.
DJ. I'm sorry, so are you now, is it your testimony that you and I did not speak other than for me to serve you with our protest notice on May 8th?
No.
That is not your testimony, or it's your testimony that you and I did not speak?
I mean, you keep asking me the same questions. The first time we had a conversation, somebody, white person, you want to buy your license. If you want to sell it, I'll introduce you. If it's not, there is no negotiable to protest the license. That's the first conversation between me and you. Even I had a text message, you text me that.
DJ, do you have any evidence of the text messages that you're alleging were sent? I'm not even sure when or to whom or by whom, but do you have any evidence of any of this?
When he texted me, said potential buyers you have if you want to sell it, and otherwise gonna protest. I had evidence. I can submit it the board if you want.
DJ, if it was true, if this were true, if any of this were even remotely true, and you had the text messages, why wouldn't you have already provided them to the investigator or to your attorney?
You never asked me the investigators.
Well, Mr. Bianco is a pretty decent ABRA attorney, and he's pretty thorough, as evidenced by the submission of, I don't even know how many pictures of the inside of your establishment. So are you telling me that despite making allegations like this, which much to my chagrin are racially charged and frankly completely fabricated, but that said, are you telling me that you provided this statement to the investigator, and I presume you discussed your testimony with Mr. Bianco, that he never asked you whether you could support any of those statements or claims?
Is there an objection, Mr. Bianco?
Yes, it calls for privilege.
I'm going to sustain the objection. Let's move on. I think you have clearly, this is not from what I'm hearing here. I mean, what you stated, Mr. Strickland, is that some investor wanted to buy a license on the block. The block clearly wanted this Italian restaurant to continue. For whatever reason, the Italian restaurant is not there. Where we're going with this is not relevant to the board. Let's move on, sir. This is a protest hearing, a substantial change. He wants to change his license category. It's a substantial change to change the license category, but the current restaurant, the only change that would be different is the capacity. But all the endorsements that is on the license, he's asking to be carried on to the new license. The only difference that he's asking is to change the category and to change the capacity. But if it was operating, or there was a restaurant, if it was operating as a nightclub, he could still do that today, irrespective of what decision, because of the endorsement that's currently with that license. So I'm not quite sure why we're spending all this time talking about some other person approaching the neighborhood because of what they want to do on the block. That's not helping us.
Well, Mr. Chairman, the reason for addressing this is multifold. Mr. Bianco presented this evidence and then attempted to elaborate on it based on his own statements and assertions in order to try to undermine Westminster Neighborhood Association's credibility, or perhaps my own credibility, which, as you might imagine, we would like the opportunity to rebut, and I also take significant personal exception to. Notwithstanding that, so trying to rebut that. Notwithstanding that, I'm also trying to demonstrate that the Westminster Neighborhood Association on multiple occasions made good faith attempts to reach some kind of resolution that might be financially of interest to DJ and to other potential businesses that wanted to operate something other than a tavern, effectively a nightclub in the community. That's all. That's all I'm
I
trying to
hear you,
establish.
sir, but you cannot. We're having a protest hearing today, and he bought a license, and you can't tell him. You can make suggestions to him about what would be beneficial to the neighbors.
I agree, and that's
doesn't have
all I'm trying to establish. That that's fine.
But
Mr.
he
Chairman.
doesn't have to agree to that, and that's why we have
That's
why we have a protest hearing today. He doesn't
Okay,
have
no
to
further
agree.
questions, Mr. Chairman. Thank you.
Thank you.
You can put that.
Any questions by the board members? Go ahead, Mr. Short.
Thank you, Mr. Chairman. I'd just like to ask Mr. Denelli, and I hope I got his name correct.
Daniel.
How many years have you been in the nightlife business in the District of Columbia?
More than 15 years.
Starting back when?
2000. I got the license 2000, probably 5.
What was that?
2005.
2005. And in that time, since from 2005 until this date, 2022, have you ever been to Arbor for any training on alcohol laws in the District of Columbia?
No.
You didn't think it was important to know the laws and you running these different businesses since 2005?
We start a license from liquor store.
Okay. The liquor stores still have to know the Arbor laws also, don't they?
I do know the Arbor laws.
Okay. Have you ever had any training at Arbor or any other place about alcohol laws in the District of Columbia? And if not, why?
No one enforced me to do that.
Have you ever had any violations with any of your alcohol licenses since 2005?
Objection, relevance, the relevant time period for consideration of violations per statute and regulation is the last 4 years at most.
All right, Mr. Chairman, well, I'll rephrase that question. In the last 4 years, have you had any Arbor violations?
No.
In the last 4 years, you've had none in any of your businesses. You're under oath.
So one violation that's warning on entire my license. It been running
Mr. Chairman, that's all I have. He said no once, and now he's saying yes, he did. That's all that I have to question to this person at this time. Thank you very much, sir, for your testimony.
Thank you, Mr. Short. Any other questions by any of the board members? Mr. Stockline, any questions of the witness based on the question that were asked by Mr. Short? Briefly.
No, I would be thrilled to move to closing arguments.
Any redirect, Mr. Bianco?
None.
Thank you. Thank you for your testimony, sir. Mr. Bianco, do you have any other witnesses?
I have no other witnesses. The applicant rests.
Thank you. So, Mr. Stockline, you're saying that you're just going to you're not calling the witness. You're just going to do a closing.
That's correct, Mr. Chairman.
You ready to do closing, Mr. Bianco?
Yes.
Go ahead, sir.
Bear with me for 1 second while I bring up my closing. I had it open and then I just lost it.
Do you want us to take a brief recess?
Can we take 5 minutes so I can just gather my closing
All right.
orders?
It's 5:47. It's 5:57. We're off the record until 10 minutes after 6. We're back in the record. We are back on the record. Are you back, Mr. Stockline? Mr. Stockline, are you back?
Yes, Mr. Chairman.
That's one of the reasons why I've asked everyone to be on camera, because I can tell when they're back. All right, go ahead, Mr. Bianco.
Absolutely, Mr. Chair, members of the board, thank you very much. We are here today on a peace order quiet protest with the parking and traffic component included. It's very, very important that you bear that in mind, because what we are not here about is over concentration of licensed establishments in the relevant area. That is not a protested issue. It's not in front of you, despite the protestants' efforts to make it an issue in this case. Speaking of the protestants trying to make an issue in this case, they didn't put on a case. They offered no evidence. And then they come here and express frustration, complain of due process, notwithstanding the fact that they failed to do a single thing. They send in a boilerplate protest letter that didn't even specifically address this particular establishment. They didn't bother to file any witnesses or any exhibits. They put on no evidence whatsoever here today, but cry foul. It's audacious. My client wants to operate a business in a manner comparable to 55 others within the relevant area. He put on evidence of his current operations as a CR. He put in evidence of the measures that he has already taken to mitigate noise. He put on evidence of his intended operations and the measures that he has and will take to make sure the operation will operate safely. We heard from the investigator and we heard from Mr. Daniil. The investigator didn't raise any issues on anything that would potentially adversely impact the protested issues, found no violations during any of the visits. Nothing in the investigative history indicates there are any violations, and notwithstanding the desperate efforts, there are no violations to consider in this particular case. WNA has tried really hard to make this case about other establishments. It's not. It's just not about other establishments. And they're doing it to try to make up for their unwillingness or their inability to participate in this process at any stage. They try to drag in contested findings from other cases, and to the extent that they're even relevant, it's impermissible to bring them in due to the contested nature of those particular elements of an order. If they wanted to discuss these things, assuming they could pass a relevance test on whatever their issues are, all they had to do was put on evidence. They didn't. They chose to put on no evidence. They chose to do nothing. The palpable desperation to play gotcha is not what this process is. And I don't know how we got here with ANCs and citizens associations filing protests for no reason other than delay, sit on their thumbs for 6 months, and then not even bother to put on a case. And what do we have next? A request for a briefing. Let's drag it out another 3 months. And as Mr. Steckline alluded to in his remarks, the marathon 9-hour case of Empire Lounge where they made such a request and then didn't even bother to file a brief. It's an abuse of the process. It's an abuse of the process. It's rampant. And if they have a legitimate beef, I'm not saying they can't bring it. Let them bring it. Let them put on evidence. But to show up empty-handed, just to drag out the process, make it take even longer, and try and choke out a business they decide they don't like is a disgrace. There's no evidence here and no reason to deny this particular application. We have more than met our burden in this case, and we know at the end of the day, upon consideration of the actual evidence and not argument and hearsay and nonsense, the board is going to make the right decision based on actual facts. Thank you very much.
Thank you, Mr. Bianco. Mr. Strickland.
Thank you, Mr. Chairman. An establishment that locks its doors creates dangerous crowd control issues in the event of an emergency, impedes the ability of first responders to enter the premises and provide assistance, and is indicative of efforts to impede and interfere with law enforcement and hide illegal behavior. Therefore, the board is persuaded that the privileges to provide nightclub activities are not appropriate where the ownership is engaged in behavior that may endanger patrons at the establishment when the establishment hosts large crowds. If those words sound familiar, that is because they are taken directly from an order that you, the ABC board, issued just 1 year ago. In that case, you ruled that the applicant should not be granted full privileges to operate a nightclub or provide other nightlife related activities. That applicant was the same applicant that sits before you today, Mr. Daniil. The very same applicant who comes before you today asking for permission to operate the exact type of establishment you found that he was unfit to operate just 1 year ago. I will note that there is reference to nightclub in the quotation. However, it is referring to, in fact, a CT licensed establishment, which is the same as is being requested here. The applicant has the burden to show that his establishment is appropriate for its location and that the applicant is able to manage it appropriately. Mr. Bianco has attempted to shift the burden to the neighborhood. That is not what is required under law. Mr. Bianco and the applicant bear the burden, but they have not presented any evidence or testimony today that should properly provide you with the basis to grant the very privileges that you saw fit to deny just last year. All that we have heard in terms of an enforcement record over the past year is effectively based on a restaurant operation with a limited number of patrons, dating back not even as far as 12 months. That is not the relevant enforcement record for you to consider. It is the enforcement record related to Mr. Daniil's activities across all of his establishments. But regardless, again, Mr. Daniil has the burden in this case, and he has not shown that this record has anything to do with his actions or competence to operate the requested tavern. He has presented no evidence that he has improved his management capabilities, no evidence of remedial actions in the clubs in which, in the establishments in which you have found problems, no evidence of additional training, no evidence of physical changes to the premises that he owns to resolve a multitude of issues that he has had in the past, and no evidence of improved hiring and employee discipline. On the issues of noise and crowd control, the applicant has presented no evidence that he has taken or is taking any efforts to address crowd control on the street and queuing. or the issues that will most certainly arise if he seeks to draw 3 times roughly the capacity of patrons to his club, where they will park, where they will drive, where they will walk, etc. There's no evidence that either the building or the owner are able to handle such a dramatic increase in occupancy and a conversion from a restaurant to a tavern effectively operated as a nightclub, especially when the proposed establishment is immediately next door to the exact same type of establishment that the owner has demonstrated an inability to effectively manage. Investigator Miller made several key observations in his report and testimony that provide great cause for concern, both to the neighborhood and I hope to this board. The mayor has seen fit to convene a task force focused specifically on the 1900 block of Ninth Street, comprised of representatives from almost 10 different city agencies. Why? Why is that? You also heard that the concentration of clubs and licenses within the immediate 1 block vicinity is 55. 55 ABRA licenses. There is no other area in the city with that density. And yet the request before you is to add just 1 more and triple the capacity of the existing license. There is simply no more room for those activities in our neighborhood, and it is impossible for peace and safety to be maintained if you grant this application. The bottom line here is that without any additional facts, you must reach the same legal conclusion that you did in the Signature Lounge proceeding. And we ask, therefore, that you deny the applicant's proposed substantial change application. If you are unwilling to do so, however, we would request that you place conditions upon the operation of VIP Lounge and those in line with those that you replaced on Signature Lounge to prevent it from becoming the same kind of establishment and having the same significant adverse impact on the community. On a final note, I would like to directly address on the record the false statement attributed to me by the applicant in which he implied that racial bias exists in this proceeding and is somehow playing a role in WNA's protest in this case or in my representation of the Westminster Neighborhood Association. Those things should not be taken lightly, and they are not taken lightly by me. Racial bias, and I hope each of the members of this board hear me very clearly, despite anything else I've said today, hear me clearly now. Racial bias has no place in our community, and that is my position and the position of the WNA, has no place in any other community. One of the best aspects of the community that represents the Westminster Neighborhood Association is its diversity, racial, ethnic, religious, and otherwise. The applicant's fabrications are a disgraceful and extremely disappointing attempt to discredit WNA and to distract from the real issues at hand. And there is no place for those tactics in this venue or any other. Thank you for your consideration.
Thank you. The record is now closed. Do the parties wish to file proposed findings of fact and conclusion of law or waive their right to do so?
We will reserve that right.
And when will you let us know? I mean, all right, okay. If the parties choose to file proposed findings of fact and conclusion of law, the 90 days from when the board receives proposed findings of facts and conclusion of law, we will issue a decision. The proposed facts and conclusion of law are due to the board 30 days after receipt of the transcript. The transcript will be emailed to the parties in approximately 3 weeks. If you change your mind, I would ask that you provide the agency and Mr. Bianco notice whether or not you will proceed with this matter. If you change your, as I said before, if you change your mind about filing, inform the board and the agency as soon as possible, please. As chairperson of the Alcohol Beverage Control Board for the District of Columbia, and in accordance with DC Official Code Section 2575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 22 PRO 00053 VIP Lounge, pursuant to DC Official Code Section 2575 B4A of the Open Meetings Act, and deliberating upon case number 22 PRO 00053 VIP Lounge for the reasons cited in DC Official Code Section 2575 B13 of the Open Meetings Act. Is there a second?
Short, I second.
Mr. Short has seconded the motion. I will now take a roll call vote on the motion before it's now that it's been seconded. Mr. Short.
Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed, I hereby give notice that the ABC Board will recess this proceedings to hold a closed meeting pursuant to Section 2575 of the Open Meetings Act. I would like to thank the parties for their presentation today, and the board will take this matter under advisement. Again, is Mr. Strickland, is he still here? Well, he presented his case, and but anyway, all right. Thank you for your presentation today, sir. Have a great day.
Thank you, Mr. Chair. Thank you, members of the board. Have a nice night.
All right, thank you. All right. As chairperson of the Alcohol Beverage Control Board for the District of Columbia, in accordance with DC Official Code Section 2575B and Section 2575B14 of the Open Meetings Act, I move that the ABC Board hold a closed meeting on October 5th, 2022, for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the matters identified on the board's legal, licensing, and investigative agenda for October 5th, 2022, as published in the DC Register on September 30th, 2022. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. I will now take a roll call vote on the motion before us now that it's been properly seconded. Mr. Short.
Mr. Short, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed, I hereby give notice that the ABC Board will hold this closed meeting pursuant to the Open Meetings Act. Notice will also be posted on the ABC Board Hearing Room Bulletin Board, placed on electronic calendar and APRA's website, and published in the DC Register in as timely a manner as practical. We're adjourned for the day. I would like to thank the members of the public who have signed on and participated in this hearing today. Also, the board members for their attention. Thank you very much. Have a great day. I will now direct all board members to return to executive committee for further development. Thank you. Have a great night.